Good morning all. This case management conference is in the matter of CFI 009-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Holman Fenwick Willan. Lead counsel is Mr. Sharif Shivsi KC. The defendant is represented by Jones Day, and lead counsel is Mr. Tom Montague Smith, KC. Thank you.
Yes.
Good morning, my lord. Thank you for convening this hearing early in your day. Can I just check that I heard from the registry that we were down for 2 hours today? Is that still the case, my lord?
As far as I know, yes.
Very good. I just raised that because there is a lot on the agenda and we'll need to use our time wisely in order to get the most out of today's hearing. I suspect we won't get through everything on the agenda, but we'll do the best we can.
Well, I have no particular time limits. So I today, other than ordinary living, so to speak, I've got no further engagements today. So that I can sit late, but of course the court staff you need to bear in mind.
Of course. Well, I'm grateful for that indication, and we'll obviously move as swiftly as we can. I think the logical starting point for today is really just to look at the timetable, where we've got to, and what the next steps are in this litigation.
Yes.
I think it's useful to provide the court with a bit of an update as to where we are, in particular on disclosure.
Well, I mean, to state the obvious, the question is, is this case going to be ready or not come October 2025? And if realistically it isn't, the sooner one recognises that, probably the better. But I'm very loath, obviously, to even start thinking in those terms.
Well, quite. We're 13 months away from trial, and there is, in our submission, sufficient time to get this case in order between now and then, although the current state of play, we say, on the defendant side is regrettable. The main focus we submit today should be on the forthcoming deadline for disclosure of the 8th of November. And your lordship ordered that there should be standard disclosure within the English sense back in April. And your lordship set down the deadline for disclosure as the 8th of November back in the hearing in June. And your lordship at that stage ordered that the disclosure deadline should apply to all parties and to capture all documents, irrespective of whether they were subject to a letters rogatory. Now, as your lordship knows, the disclosure exercise effectively involves 4 stages, and this appears to be common ground. The first stage is harvesting of data, and that's without the application of search terms. I think there may be a bit of an echo on the line. I'm not sure if anyone else has got their video unmuted. So there's 4 stages. The first stage is the harvesting of data without the application of search terms. The second stage is the processing and upload of data. The third stage is the application of search terms. And the 4th stage is the review. And I just wanted to highlight that the first stage, the harvesting and uploading of data, is done without filters being applied. And that's done for 2 reasons, and that seems to be clear from both the authorities and is common ground. And the 2 reasons are these. Firstly, that day-to-day IT systems have their own limitations in terms of correctly applying search terms. And secondly, they do not leave an audit trail. And so for those reasons, good e-discovery practice involves uploading all of the data to a disclosure platform and then applying filters, search terms, etc. later. And I don't know if your lordship had a chance to look at the CABO authority that we cited in our skeleton. We might look at that in a moment, but in that case, essentially the disclosure went off the rails, we say, much in the way that it's happening in this case, and it led to a very late adjournment of trial and all kinds of disruption. We'll look at that, as I say, in a moment. Now, what the authorities do is they emphasise the importance of involving solicitors and independent professionals in the disclosure process. And in an English disclosure exercise, it's particularly important to involve those with experience of English law. And that's something your Lordship has already highlighted in this case at a previous hearing, the importance of involving those at Jones Day. And you may recall that at a previous hearing, we looked at a passage from Matthews and Malik, which is at 3109 of the bundle. Does your Lordship have that? It's at the top of the page. This is my skeleton argument from the last hearing. It's the solicitors obviously involved right from the beginning. The best way to fulfil their duty, the solicitor's duty to the court, and to ensure that the client is fulfilled too, is to take possession of all the original documents as early as possible. And of course, clients shouldn't be allowed to decide relevance or even potential relevance. Now, for that reason, the client-led exercises are unsatisfactory and to be avoided. And that's a fortiori in this case, where the two most senior legal professionals on the defendant's client side, that's Mr. Astruct and Mr. Gribby, are themselves accused of dishonesty. And that was the point, again, that your Lordship drew attention to at the June hearing. And if we turn up the transcript there, that's at 2184. And you said there, in this case, what we have is an allegation of fraudulent conspiracy made against a number of defendants, including the individual directors and Mr. Astruct, who is the general counsel. In those circumstances, it seems to me that he cannot be the person who is responsible for decision making because of the allegations made against him individually. Of course, he will give instructions on his own behalf to you, Ms. Martin. That is inevitable and must be the case insofar as you act for him as well as acting for others. However, when it comes to disclosure, someone independent from him has to be the person who takes responsibility for decisions. It is also true to say that not only must there be independent supervision by someone of sufficient seniority and responsibility on behalf of the fourth and fifth defendants, but there is a need for supervision and direction by the lawyers involved, namely Jones Day. So, my Lord, that ought to be uncontroversial in terms of the landscape of what is required. On the claimant side, we've obviously heeded that guidance. We've engaged e-discovery specialists and Cura, and we have carried out the first and second stages, which is the harvesting of data without the application of search terms and the upload of data to the platform. For some custodians who were added relatively recently, we're still in the process of getting them fully functional on the platform. But the sort of main tranche of our data is already up and available for search and review. And as I understand it, we are, as this hearing is running, uploading and processing the remaining data. So that will all be ready as well. And we've already embarked on the third and fourth stages of our disclosure exercise, and we are on track in terms of the court's disclosure deadline of 8th of November. And our data is on essentially a disclosure platform that is cloud-based and is available to our legal team.
That's with agreed search terms, is it?
The search terms have not yet been agreed. We sent search terms to the defendants a week ago, and I understand that they need another 2 weeks to look at the search terms before they come back. So they say they'll require a total of 3 weeks. Of course, the sooner we hear back, the sooner that we can refine our own search process, but we're not waiting for that. There's plenty that we can get on with in terms of what we know we want to do. So that's our position. We are on track. Turning to the defendant's position, they are not on track. They seek an extension of 2.5 to 3 months to complete their disclosure, and that's to complete their disclosure, which is not subject to the letters rogatory. They say that the letters rogatory process will be initiated after that 2.5 to 3 months extension, but they provide no timescales as to when that will be completed. They say that if they're required to carry out searches beyond what they're willing to do, then the process could take some 6.5 to 9 months. And again, that is before the start of letters rogatory. Now, they suggested to us in their letter of last week that the trial date was in jeopardy. but they now seem to row back from that statement in their skeleton for this hearing. The court of course, gave them 6.5 months to complete the standard disclosure exercise. So that's from when the court ordered it in April to the deadline in November. And although the defendants have previously sought to get the court to make an order to this effect, the court did not separate out the timetable for any documents subject to the letters rogatory process. That's the point that the defendants have tried to get an order from the court and not succeeded on. Now, the authorities on how the court approaches extensions will be well familiar. There is a Court of Appeal decision in Latcan and Lamia at 2994 of the bundle, which sets out the basics. This is, I think, a decision of Mr. Lord Justice Giles sitting in the Court of Appeal, DIC Court of Appeal. And at paragraph 42, he says, and this is routine, we say, when any application is made for an extension of time, the matters to be assessed in the exercise of the court's discretion will usually include A, the length of the extension sought, B, the justification given for the delay, and C, whether, and if so, what prejudice has been suffered by the other party by reason of the delay. And of course, a party who seeks an extension of the court's timetable, in particular any material extension, would be expected to make an application supported by evidence. And evidence is usually necessary because the court needs to examine carefully the strength of the reasons for the extension and also the prejudice suffered. And where delays have occurred, the court will want to understand what the cause of those delays were and to ensure that they're not repeated. Now, in this application, the defendants have not put forward any application and no evidence at all. Now, no doubt my learned friends who will be well experienced in this explain to their clients that evidence in such applications is routine, but it must be inferred that the defendants took the view that they had no useful evidence to give. And that in and of itself is good reason to treat this application with great scepticism.
Well, Mr. Shipji, my initial reaction is I have no application, so it's not on the menu. But the position is that the court has got itself to take a view about these things and probe the position. Yes. So that I'm not treating it as though the defendants have made an application at all. Right. So in a sense, it's better to wait to see what Mr. Montague-Smith has to say. And if the court at the end of the day looks at the realities and decides that one course or another is appropriate, well, I suppose that's that. But it's plainly not sensible to ignore a potential elephant in the room.
Yes. Well, I think my learned friend brings the elephant in his skeleton argument, but then doesn't essentially position it in a place where the court can do anything with it. So I'm sorry, my lord. That's our, I think, a sort of test for our alarm rather than the building on fire. And then it stopped. But I think we would certainly encourage the without mixing my metaphors for the court to grasp the nettle, because what we have before us is a case that is running off track, and if it's not brought back on to track, then yes, we will end up with a problem down the line where more expense is incurred. And so we say that even though there isn't a formal application before you, essentially the court needs to scrutinise the defendant's reasons why they are where they are, and then provide what guidance it can to getting the defendants back on track. And the outcome we seek today is for the court simply to reinforce that disclosure deadline as ordered remains in position. And there's still 6 weeks to go. And as I'll come to address you, there is the defendant's extremely well resourced. They have a firm of solicitors engaged who themselves are experts in very large disclosure exercises. And there is actually no evidence before you to say that this can't be done on schedule. Now, of course, there's the letters rogatory component, and I'll come to that separately. But my submission is that if serious headway is made on the actual disclosure exercise, then that will allow enough time for the letters rogatory process. But what we can't have is essentially all of it being kicked off in the hope that it will somehow miraculously come good later. Now, what my learned friend said in his skeleton argument and his draft order is that he wants an extension of 2.5 to 3 months. He does seek an order to that effect, even though he hasn't made an application. And that, we say, is a long extension, especially when one takes into account that it doesn't take into account letters rogatory, as the existing deadline does. And assuming for a moment that the letters rogatory process takes 3 months, then really what my learned friend is asking for is for the deadline to be pushed back by 6 months. And that is objectively, obviously, a very long extension. It's a very surprising extension to be sought so late in the day. This extension was first raised last Tuesday, just before midnight, when we received the draft order that said for the first time that they wanted to move back the deadline by 2.5 to 3 months. So it's a long extension on its own. It's a long extension relative to what the court has already granted. The court gave the parties 6.5 months to carry out disclosure. We're about 5 months into that. And this is not one of those cases where the disclosure exercise between the parties is in balance. We're both searching similar numbers of custodians over a similar period, and the claimants are on track to hit their deadline and the defendants are not. Now, just in terms of the James Day's expertise in this area and the size of this exercise, this is a point that Ms. Martin made at the last hearing at page 2170 of the bundle. And the point she was making there is that in a case, this sort of case, the disclosure exercise is tiny in comparison to the sorts of exercises that James Day normally carry out. And she said she was persuading your lordship that her firm knows how to run a disclosure exercise. She said, we know how to run a disclosure exercise. I mean, I think if my firm is known for anything, it is for tort mega litigation in the US, where if you had a case only with a couple of million documents, that would be considered a small case. We know how to run a disclosure exercise. We know how to get the information. We take our duties very seriously. And she goes on to say later, so of course, we're not going to just sit and let the client run a disclosure review exercise, but we do have to ask them for information, blah, blah, blah. So James Day no doubt have huge expertise in running an exercise like this. And sorry, just a final point on the length of the extension. The extension is also significant in relative terms, given the time left available between now and trial. The court had set a deadline that allowed 11 months between the disclosure deadline and trial. On a like-for-like basis, my learned friends are asking for effectively is for disclosure to cut back so that it's about 5 months between disclosure and trial. And if that were permitted, that would, we say, make trial unworkable, because there just wouldn't be sufficient time for the usual things to happen after initial disclosure, including any challenges to disclosure and specific disclosure, obviously review of the documents, witness statements, expert reports, etc.
What in your view is the minimum period that should be allowed between completion of disclosure, not including letters rogatory, and trial date? What's the minimum time that is realistic?
Well, it's the letters rogatory that makes it difficult, my lord.
Well, I understand that.
And sorry to cut across you.
Well, I understand that, but earlier you talked about, I think, about 3 months.
Yes.
And, you know, that's fine if diplomatic ends get on with it. It is, as you say, impossible to be precise about that, and experience does not suggest expedition on the part of, being frank, either end. Yes.
Well, so my lord, there's a number of answers to that. I mean, one is that at the previous hearing, my learned friend Ms. Martin was keen to emphasise that a lot of the documents will not be covered by issues of banking secrecy and letters rogatory. So, I mean, I see what my then friend Mr. Montague Smith says in his skeleton argument about the seriousness of these restrictions. But even putting that to one side, and before one gets into any sort of bank merit exercise, there is a vast amount of material that will not be covered by these restrictions. And it seems from their analysis that really they're only talking about certain client-related material with certain client-related restrictions. So I think it's important not to overstate that if the latest rogatory process is used, that it ought not to slow down the progress in essentially the bulk of the disclosure to be given in this case. That's the first point. The second point is that we say it was for good reason that at the last hearing the court did not accede to the defendant's request to bifurcate the timetable and have a different deadline for non-rogatory documents and documents subject to letters rogatory. Your Lordship set the deadline. It's on the defendants then to do what they needed to do in order to get themselves comfortable to disclose the material. And they tried and failed at that hearing to persuade your Lordship to separate the two. And essentially what they're trying to do again is achieve the same result through separate means. And they shouldn't be permitted to do that. But we are content for them, in the first instance, just to get on with their disclosure exercise and produce their list, and then to launch that letters rogatory process as soon as possible. On that, I think, again, the exercise is sort of slightly morphed in the defendant's language from what they were originally proposing to what they are proposing now. So previously, Ms. Martin had suggested to you that the letters rogatory process could allow certain categories of documents to be provided. She gave you the example, for example, of board papers over a certain period. That could just go into the letter of request without specifying all of the documents. In some areas, she said that there needed to be a greater level of specificity, but there has been no suggestion then, and there is now, that they actually need to run the full disclosure exercise and set out the full list of documents. And so we say that actually they could, before even finishing their disclosure exercise, they could launch a letters rogatory now. They could do so by reference to categories of documents. We understand the point about it being specific, but they've had 5 months to work out specifically what categories of documents they're likely to have. And we say no reason why an initial letter can't be sent now. It may well be that there needs to be a second letter later, but at least the wheels would then be turning on a process. So that's the first point. The second point is we say that they should be held to the 8th of November to complete their disclosure review, even if the letters rogatory go after that. I mean, realistically, where we are, we recognise that even if the letters rogatory went now, that you're unlikely to get a response by the 8th of November. So we are where we are on that. But we say that they should still have completed their exercise by the 8th of November. And they haven't put forward any evidence before you to say that it couldn't be done. But any evidence at all before you as to what they have been doing. Now, I wanted to just look at that, my lord, in a bit more detail, because we say that the reasons why they are behind schedule and why they need extra time are really unsatisfactory. And there are 5 pieces to this. The first piece is their in-house disclosure platform. Now, in addition to the usual stages for disclosure that I identified to you earlier, they have inserted an additional unnecessary stage, which is that they wish to build their own in-house disclosure platform for the 4th and 5th defendants. And that decision to build their own platform appears to be one made by Mr. Astruct and Mr. Gribby. And that's in Mr. Tourette's statement at paragraph 68, which is 498 of the bundle.
.498.
Yes. Now, it's paragraph 68. Now, earlier in Mr. Tourette's statement, he explains that he's carrying out the disclosure exercise independently from instructions or influence from Mr. Astruct. But then he says at 68, I understand from Mr. Gribby and Mr. Astruct that as a general matter, where a third-party provider is used to host documents of BGSS on an e-discovery platform, any such provider builds out a server on-site at BGSS for data security purposes. And that seems to be a direction from Mr. Astrup to Mr. Gribby. And it was said to us in one of the disclosure meetings that this was a policy of the fourth and fifth defendants, although no policy has ever been produced, and that point has not been repeated in correspondence or in evidence. Now, we say that in this day and age, trying to build your own e-discovery server is unnecessary and probably expensive complication. It's suggested this is being done for data security reasons, but we don't understand that. It's perfectly possible to have devices connected to the cloud and still be secure. We have all of our data on the cloud in a secure platform, and that is, we say, the way that e-discovery is done these days. Now, that the e-discovery server has caused enormous delay on the defendant side. It's now 5 months since the court ordered disclosure, but the defendants have delayed their entire disclosure exercise because they could not decide which server to procure. And they've dressed up that point as a point about whether they didn't know whether or not the data exceeded a particular size. And it was claimed that the server would involve significant fixed costs, which is why they deferred the decision. And if you look at their letter at 2750, so this is their letter from Tuesday at midnight. This is in section 3. They say at 3.2, in order to procure an appropriate server, we need to know the approximate size of data to be processed, which depends on the number of custodians, a matter yet to be determined. Should the data in each of Dubai and Switzerland be less than 1 terabyte, some e-discovery providers are able to deploy high-performance mobile servers, which can be installed and operational within 4 to 6 weeks. However, if the data exceeds 1 terabyte, higher capacity fixed servers will be required, which could take between 6 to 8 weeks for deployment, but that time frame is dependent on potential customs and importation issues where relevant. Now, there are a number of aspects to this that are unreal. First of all, the size of the data is negligible. 1 terabyte is the size of the new iPhone, which was released, I think, last week. It is a drop in the ocean in terms of the universe in data. And the defendants also know, because we said it in our EDQ, that the data in the office holder's possession exceeded 2 terabytes. So they know from our side the amount of data that they might have in play. Now, it's striking that this point about commissioning the servers is no longer made in my learned friend skeleton. They now say that they've found a server, and that's at 2860 of their skeleton, and that's paragraph 5.1. They say to expedite the process in Switzerland, an existing e-discovery server shall be utilised for the searches in relation to Swiss employed custodians at D4. And they no longer make the point in this skeleton argument that they somehow now need to wait to sort of understand the full size of the data before commissioning that server. Now, we say it's remarkable that it's taken them 5 months to do anything because they couldn't decide which server to buy. And then it turns out that they had one lying around anyway. Now, we also say it's striking that nowhere in the correspondence on my learned friend skeleton do they say that they have appointed an e-disclosure provider as yet. They say that they were looking, but they don't say that they've appointed one. And if one goes back to that letter of last Tuesday at 2751, in fact, we say the reasonable inference is that they've not provided one, or at least they had not appointed one at the date of the letter. And that's at paragraph 3.5.
Sorry, can you just repeat that again?
Yes, my lord. So if we look at 2751, paragraph 3.5.
Oh, sorry, yes, I was looking at different, yeah.
So this is the letter from Tuesday. They say, we've made appropriate inquiries regarding the cost of relevant servers. Multiple procurement methods are offered by various e-discovery providers, each with their own cost and time considerations. As you are aware, not all e-discovery providers have the same capabilities or provide the same services. We say the obvious inference from that is that they hadn't yet decided which e-discovery provider to go with. And again, we just don't understand how they can find themselves in that position so long after you ordered disclosure. And bringing us back to the learning from Matthews and Malik about solicitors taking possession of the documents at the earliest opportunity and taking into account Jones Day's significant experience in this area, it's a reasonable inference that they would have told their client that they needed to get in early to capture the documents and that they wanted to do it. I mean, it's unthinkable that Jones Day wouldn't have done that because they know how to run an exercise like this on time and on budget. And so the only inference we say is that their client must have deliberately said to them, we don't want you to do that. Do not appoint an e-discovery provider. Do not come in and capture our documents. We want to wait to decide whether or not we're going to buy a particular type of server with a 1 terabyte or 2 terabyte hard drive. What this does, we say, is really emphasize the concerns about this disclosure exercise being run in-house rather than being run with the input of external independent advisors. And it appears to be that this process is being run in-house by institutions that quite understandably have no experience of the English disclosure process. And that experience is absolutely fundamental to having an exercise that has integrity and is successful. Now, I mentioned to you earlier the Cabo case, and we think that's the insightful authority. Sorry, if I make my law, I'm just going to get a copy out of my bag, which I have here. Sorry. The Cabo case appears in your bundle at starts at 3040. It's a decision of Mrs. Justice Joanna Smith in the Chancery Division. And it's a case where just 3 weeks before trial, it transpired that there was a very significant omission from the defendant's disclosure exercise because they had missed a large tranche of documents during their data collection process. And that was a case where the client, the lay client, had carried out the data collection process rather than e-discovery professionals or the solicitors themselves. We pick up the judgment at paragraph 27, please. Sorry, actually, I'm so sorry, my lord. Could we just go back to paragraph 9, actually, because paragraph 9 explains what the nature of the case was, and in particular, the importance of the disclosure exercise. So this was an IP case about copyright infringement between two toy companies. Cabo, the claimant, was a small toy manufacturer with a particular type of product, and it brought claims against MGA, which is a much larger operator. And the complaint was essentially that MGA had carried out various collusive and unlawful conduct in order to stop Cabo's products being sold. And the judge there says at paragraph 9, she explains the nature of the case and then goes on to say it's no exaggeration to say that competition law infringements and unlawful threats under IP law are capable of being evidenced by individual emails. It's also no exaggeration to say that with the exception of the emails that were passed them by the entertainer, which is the toy retailer, Cabo had no visibility around the conduct of MGA. In the circumstances, it was inevitable that the proper conduct of the disclosure process by MGA would be of the utmost importance. And we say there are obvious parallels there to here, where essentially the claimants don't have full visibility of the unlawful conduct. They have some information about it, it's a fraud case, but of course disclosure here is of the utmost importance. If one then goes forward to 27, we can see how things went off the rails in that case. The judge says at 27 that, in my judgment, MGA's disclosure exercise took the wrong course from the outset. And then she goes on at 28 in the second sentence to say, in a letter dated 22nd of July 2021, CABE confirmed that it was content for MGA's in-house team to capture all documents from repositories and upload them onto a relativity platform, but said that in such circumstances it was clear that MGA's IT team had no knowledge or experience of disclosure in England. We still consider there should at least be supervision from e-discovery specialists in England who understand the legal requirements in the jurisdiction. And MGA, it goes on to explain that MGA subsequently confirmed that the disclosure process will be supervised by e-disclosure specialists in the UK who understand the relevant legal requirements in the jurisdiction. These will include both Freshfields lawyers and one or more e-disclosure specialists from Con.als. Now, a judge goes on to say that paragraph 30, that notwithstanding those assurances, the technical process of harvesting the documents was not subject to any such supervision, and there was no technological direction as to best practice. And then at 31, the judge says this lack of supervision appears to lie at the root of problems that then occurred, not least because, as it turns out, MGA's in-house IT team did not have the necessary levels of experience or knowledge of best practice required for the conduct of a substantial disclosure exercise of this type, involving in excess of 1 million documents. And then at 33, my lord, she goes on to essentially criticise how the process was run. So what MGA did was they applied essentially search tab parameters on the data as it sat on MGA's system. So rather than going through what I said was best practice at the beginning, that you capture all of the data without filtering or without search terms and upload the lot to a platform, instead what MGA tried to do is apply the search filters right at the beginning in order to cut down the data. And the judge is incredibly critical of that and really puts that down as the heart of the problems that then arose later. And she said, it's 33, it's clear that anyone with independent expertise in e-disclosure, had anyone with independent expertise in e-disclosure been engaged by Fieldfish to consider the appropriateness of the approach that MGA was intended to take to harvest the documents, it would have quickly emerged that the approach proposed by MGA did not accord with best practice. And then she goes on to explain that best practice. And again, that's what I addressed you on earlier, that the aim is always to export the, she says this at the end, in the sort of middle of 33, referring to the expert witness, Mr. Nicol of Kroll Associates. She says, Mr. Nicol expresses the view, amongst other things, that the advice of Mr. Sweeney to export a full universe of data to be limited later should have been considered as the most robust and defensible approach, particularly given the scale and gravity of this litigation. So what happened is they ran an exercise initially in-house, filtering the data, putting it on the platform. And what happened later is it transpired that that data capture exercise was erroneous and that they had missed a very significant amount of data. And the judge picks here in a bit more detail exactly where the red flags were and how they should have been spotted along the way. But we say that there are obvious parallels between what went wrong in the MGA case and what's going wrong here. The defendants don't have e-disclosure providers on site. That seems obvious. They haven't uploaded their data. The solicitors haven't captured the data as they ought to have. The data hasn't been uploaded to a recognised e-discovery platform. Building your own server in-house is obviously fraught with difficulties. There's no evidence that the defendants have any experience of building a server or running it or updating it, or even what software will be run on the server and whether that is a form of software that is recognised in an English-style disclosure exercise.
Going back to paragraph 5.1 of the skeleton, that refers to searches in relation to Swiss employed custodians alone, not to anything else as I read it. I'm troubled about quite what is being said in 5.1, but no doubt Mr. Montague-Smith can explain either now or in due course how far they've got on and on what basis, and whether there's any distinction being drawn between one lot of people and another lot of people, or one location and another location.
I do understand. Your lordship's absolutely right. My understanding. I've been focusing on, of course, in the position in Switzerland. But your lordship's actually right. That is actually just talking about the position in Switzerland. D5 is based in Dubai. As we understand it, they are still in the process of trying to procure a server, and they haven't done that yet. But it does seem to be the intention that they would still do that, and the timescales that my learned friend puts forward in his skeleton argument build in, he says, I think 6 weeks for that procurement exercise to happen. So it looks like on D5's side that it still needs to procure that server, but it has exactly the same. It then raises the same sort of integrity problems that I've identified. Which is that who is going to set up this server, what will it have on it, and who's going to monitor whether it actually works. Now, that probably is convenient for me then to turn to the complaints about us. So in my learned friend's skeleton argument, these failings of the defendants somehow spun in a way that suggests that this is all the fault of the claimants. We've caused problems in the process, which means that they haven't been able to procure a server yet. I think the point's made at various points in various different ways, but a good example is at 282872 of the bundle.
Well, most of it's to do with search terms, and we haven't got that far yet.
Yeah, well, so that is one of that's
your basic point, isn't it?
It is my basic point. I mean, and all my learned friends' analysis, because they need 6 weeks to procure a server, and then another 6 to 8 weeks to capture the documents, upload them. They're essentially 3 months away from applying the search terms on their timescales. So, I mean, the idea that somehow we're to blame for slowing them down. I mean, the complaint is that it took us 6 weeks to respond on their search terms, and that happened over a period where the parties were in settlement discussions, and we said in our skeleton argument what the agreement was there. But in any event, even if we should have come back quicker, and we should have come back in 3 weeks, they still want another 3 weeks to look at our search terms, and they are, as I said, 3 months away from applying them. So it is just unreal to suggest that we are to blame for this. And I think the best example of how one should carry out is how we've done it, which is, although everything hasn't been agreed, we've just got on with what we can do. And the truth is, there's a lot that we can do, because there were lots of 10 custodians have only been agreed this week, but even then we had other custodians we could get on with. And the process of essentially gearing up the team, briefing them, and making sure that our search terms are working, making sure that our relevance rates are appropriate, all of that work can just get underway, and that's what we're doing, and that's what you need to do in order to meet the court's deadline. Now, insofar as my learned friends say that, well, because there's still a dispute about certain custodians, that stops them from even starting their exercise. And again, that's just a bad point by reference to what we've done. I mean, it's striking on custodians that they resisted our proposed custodians and then have conceded 10 in the last week. But even then, they should have just uploaded the ones that were agreed, and they could have got on with those. And they would have been, if they'd done that, they would have a functioning disclosure platform, and then it would be easy to do what we've done, which is as and when new custodians are added, you just upload them and process them in a matter of days. And those are the timescales that are applying on our side. We don't understand why they don't on theirs. Now that perhaps brings me to just the circumstances in which this extension was first identified. We received a letter from the defendants on the 10th of September, which was phrased in a very coy way, suggesting that issues with agreeing some of these search parameters risk disruption of the disclosure deadline. They didn't put it higher than that. And then the first occasion on which they said that they weren't going to meet the disclosure deadline at all and need an extension of 3 months was Tuesday. And that, again, we say is a sort of indication that they've not been open about their position, and they've only revealed that in the last minute. Just a short word about the letters of request. I mean, my learned friend spends a lot of time in his skeleton argument about this. We're not obviously going to have an argument today about bank mail-outs. Our hope was always that that sort of exercise, which would involve evidence of foreign law and a hearing devoted to it, hopefully will be unnecessary if they simply get on with the letters rogatory process. We don't mind them going through the letters rogatory process. We don't accept it's necessary. We find it very surprising that they identified 3 new jurisdictions where a letters rogatory was required, and that was only revealed in the last few weeks. And we don't accept that it's necessary in those jurisdictions either. But we think that the most pragmatic way to deal with this is simply for them to get on with it. And the burden is on them to do this because this is for their protection. But in any event, I said to you earlier that my learned friend said to you at the last hearing that lots of documents fall outside the letters rogatory process, and that's at page 2240 of the June transcript. And she said there, we can run the whole disclosure exercise in Switzerland, and there is likely a lot of information that the court can freely dispose of, which is the legal test that can come through regular disclosure. And we are very happy to accommodate that. And she goes on to say, we will provide that directly. So there just isn't a need for everything to wait for the letters rogatory process, even for the documents in Switzerland or Monaco or where else. Now, can I turn to look at the question of prejudice? That's something that my learned friends, they don't mention the word prejudice in their skeleton, but it's a key question when a party is looking for a significant extension like this. And we say it's obvious that there will be prejudice to the claimants if the deadline is put back as argued for. Firstly, it allows no real time for documents in disclosure to be read and considered ahead of the milestone for witness statements and expert reports. Secondly, it allows no time for any arguments over the quality of disclosure given or whether the specific disclosure is required. And given the history of this litigation, concerns about deletion of documents and the fact that this is a covert fraud, it's very unlikely that we will be entirely satisfied by what we get with the defendant's disclosure without having anything further to say on the topic. The third is if the claimants are held to an earlier deadline than the defendants and there's a manifest unfairness between the parties, in that the defendants will have far longer with our documents than we will with theirs. And fourth, these proposed delays raise the real prospect that trial will be adjourned, possibly at a late stage. And really coupled with that, it's a point about costs. My client has, in accordance with the court's order, spent the estate's money working to a deadline which she understood was mandatory. And that involves a certain pace of work and effort. And we are effectively being penalised for spending the money and getting on with it in circumstances where the defendants have chosen to do nothing. Now, where does the court go from here? Well, there's still 6 weeks to go to the disclosure deadline. The defendants have not put forward any evidence to say that the task cannot be done in that time. They haven't put forward any proper justification for these on-site servers, and they're plainly a bad idea, fraught with errors, problems, as the Cabo case reveals. What they should use is a standard e-discovery provider, as we have. There are many in the market. They've been speaking to them, we know. And they should put their documents urgently on one of those platforms and get on with their review exercise. And we say, for a firm like Jones Day, they should be able to complete an exercise like this in 6 weeks. So we say that the exercise should be held to the existing deadline. And as for the letters of request, we don't accept that they're necessary, but we're content for the defendants to pursue them. But these should be prepared for issue in 4 weeks' time. And we don't accept that they need full lists of documents for all categories. I mentioned to you that Miss Martin had raised that at the last hearing. Just look at that passage. Actually, it's at 2238. Sorry, 2238. And at the bottom of the page, she was talking about my submission about how these applications are made. And she says, we agree, but it takes time and it takes compliance. And the compliance requires, as I understand it, a high degree of specificity. There are certain circumstances in which you can order categories of documents, maybe all board minutes for a certain period of time or something along those lines. But the advice that we have received, which Mr. Muller is very happy to address the court directly on, is that something like all emails between X custodian and Y custodian between a certain date range that are considered relevant to the proceedings will not fly. The Swiss courts will not order that. We need to be more specific. So we have to run our disclosure exercise first. Well, we say that's fine, but in 4 weeks, they should be able to give us sufficient specifics about what they have to be able to get out a letter of request. And as I said, although I'm not encouraging lots of items to be pushed into later letters, it is of course possible that if certain exercises are still pending and they simply physically haven't been completed and could not have been by the time that letter of request goes off, that this could be a first letter followed by a second letter. And frankly, the costs of that, which no one has said would be significant, should in any event be borne by the defendants, because it's entirely their lackadaisical efforts that have caused all of this to be done late in the day. And we also say that that letter of request should cover witness statements now. What my learned friends seem to envisage is multiple letters of request at different stages of the litigation. Your Lordship has previously said that there should be no problem with the parties identifying in advance who their witnesses will be. And we say that obviously, given the worries about delay, the defendant should identify their witnesses now. That can go in that initial letter of request. And again, that's a job done and sort out the later. Now, my Lord, I was going to pause there because this is the elephant in the room, and it might be convenient, subject to your view, to hear from Mr. Montague-Smith. But in the first instance, I don't know if you've got any questions.
Are you envisaging that the letters rogatory process would take place without you having any input?
I'm not, but I don't. But my understanding, I mean, it's strongly in the defendant's interest to get these orders out of the Swiss court. Our understanding is that they are routinely granted to Swiss banks. I have experience of that myself, acting for Swiss banks. And so, of course, we're content to be consulted, but this is really the cover that the defendants need to produce the documents that they are obliged to under DIFC law. And again, this is the point that you made to Miss Martin at the last hearing. Your Lordship said these are DIFC obligations to DIFC litigants, and they have to comply with their duties to this court. So that they can identify what they're... Sorry, Mike.
Okay.
So they can identify the documents that they say are responsive under DIFC law, and then they can make sure they've identified them sufficiently with specifics to get the order that they think they need out of the Swiss court. But all of this has been done for their... Sorry, Lord.
No. You finish, and I'll then ask my question.
I was saying that all of this has been done essentially so that they say that they can sleep easy at night. And so it's really for them to take the lead on it. But what, I mean, if it comes to it, we will have an argument over bank mail-outs. But even my learned friends have previously taken the position that that isn't necessary because they are completely content to go through this process. And their previous indication is that there ought to be no issue with getting this.
Well, there's a distinction, it seems to me, between the position with regard to witnesses and with regard to disclosure of documents. I think it obvious that the defendants must already have considered what witnesses they think they might call, but I can also understand that they may want to decide at a very late stage, the last possible moment before exchange of witness statements, who it is they think they may call, when they've seen what can be said, for example, in relation to a number of documents. In a case of this kind, that might not be an entirely surprising position to adopt. so that whilst they can get on in relation to letters rogatory for potential witnesses at this stage, if you were to see all that, that might create problems for them in terms of privilege and decisions about witnesses, mightn't it? Which is why I asked the question about input in relation to witnesses.
So we don't see an issue with that, because, as your lordship said, they can ask for permission in relation to potential witnesses, and we don't. I mean, obviously, they will have to make a final decision as to who they want to call and whether or not their witnesses are actually willing to attend. But
Yes.
I mean, your lordship's function is to try and facilitate the case management of this case so that it comes on in an orderly way. And of course, parties do make last-minute decisions to pull witnesses. Sometimes they serve witness statements and then pull the witnesses shortly before trial, and all those sorts of tactics we've all seen. But in terms of trying to administer a sensible conduct to this case, looking at the history of it, we say they should be required to apply now for letters rogatory. They should identify their potential witnesses and get permission. If there are parts of that application where there's something that they want to say to the Swiss court about the nature of the evidence to be given that they don't want to reveal to us, then we're very willing to consider whether that could go in a confidential annex that we don't see. I mean, I think our only concern would be that they don't try to actually spike the guns of the application by putting something in a confidential annex to persuade the Swiss court not to make the order. But I think subject to that, we don't mind in principle if there are things they say in that application that are privileged that they wouldn't want us to see. So there must be a way through, my lord. But what experience has told us on this case is that running things in an ordinary way, where the parties are simply just expected to hit the milestones without real management, just isn't working. And it won't work. I mean, your lordship essentially set down trial 18 months in advance, and it's a 2-week trial. It should be eminently achievable in that time. And there is no good reason for this trial to be put off. That would involve more expense for the estate. Adjourning trial, as your lordship knows, is really an extreme option, and delaying essentially the determination of justice in no one's interest, including the interests of all litigants and the public in understanding whether or not a fraud case like this is made out. So we say we would very strongly resist moving trial. They've got 13 months to get their act together. They are very, very well resourced. They're perfectly capable of doing it. And we say your lordship should make them.
Yes. Anything else you want to say at this stage?
Not on that, my lord. I've got submissions on custodians and other topics, but we say this is the one to sweep away first.
Yes, all right. Mr. Montague-Smith.
Morning, my lord. So I appear with Mr. Conte, who is here. We are both relatively new, extremely new additions to the team. Am
I allowed to ask how new?
The last week. So the actual amount of time that we've had to get our hands around this is relatively limited. However, so forgive me if we're not completely up to speed on every aspect of this. What I would say, though, is we do not accept my learned friend's characterization of the way we have got to this position. And some of the suggestions that have been made in his submissions are, we would suggest, rather extreme. And I certainly have seen no material on which they could properly be based. So there is this suggestion that, for example, that the disclosure exercise is being run by the client and not by professionals. I have seen nothing which could possibly support that allegation. And there was the extreme suggestion that perhaps the defendants had instructed Jones Day not to run a proper disclosure exercise. That is a completely unwarranted suggestion and not one that chimes at all with anything that I have seen, or indeed anything that you've been shown by my learned friend. I would just try to give you the confidence that this is going to be a professional-led disclosure exercise run by Jones Day, and we are in the process, as I understand it, and hopefully it will happen today, of appointing a Big Four firm to carry out the actual disclosure, hosting and harvesting. We haven't quite got there yet, but I'm told that it will hopefully there'll be a landing on that today. We don't accept my own friend's characterisation of what has gone to date. My lord, you should be aware that there have been a number of disclosure meetings that have taken place between the parties, and some of the things that happen in those meetings have been recorded by my instructing solicitors in letters, which were then sent to the other side to memorialise, in effect, the progress that has been made, to which in lots of occasions there's been no response. And then there's been a very recent about face. There is a significant difference between what was being discussed in those meetings and the progress the parties thought they were making, and the agreement as to what should be done, in particular pending without prejudice discussions that were going on, and the way that the case is being presented to you by my learned friend. For example, my learned friend felt able to tell you that the first time any sort of extension or the prospect of any sort of extension was raised was last week, and that is simply not accurate. Now, I can't show you that correspondence because it's discussed in WP correspondence, but it is not right for my learned friend simply to make those assertions when they are simply not accurate. Now, some of what is being said by my learned friend is simply not right. So he said, for example, just coming to search terms, and I hear what your lordship says about search terms, but actually that is a critical step in the progress towards actually undertaking this exercise. My learned friend said, you've seen what he says about the agreement in relation to search terms. In fact, in his skeleton argument, what he says is, during the course of WP discussions, there was an agreement to slow the progress of disclosure. So putting those submissions together, my learned friend is sitting here telling you that there was an agreement that his side would go slow on responding to search terms. That is simply not accurate. And what actually happened was that search terms were provided on the 1st of August and a response was promised at various stages. Now, you won't see that in correspondence because in a lot of those cases, the promises were made in the meetings, but again, they were recorded by my clients in their letters, to which there was no response. And so you get a serial promise of responses that will come back. On the 6th of August, it was said we'll do it next week. And then in the end, we only get a response on search terms on the 16th of September, more than 6 weeks later. And when that arrives, 25 pages of search terms has turned into a 70-page document. And the document says, the letter covering, and I can show you this, says, this is a very long document. It's been a very complicated document to review. It's taken us some time. And my learned friend is telling you that we need to be doing this in 4 days. We need to be responding to that document in 4 days. So the approach that is being taken by the claimants, we say, is not constructive. We are where we are. And no doubt there are things that could have been done on both sides that could have happened more quickly.
But do you accept, Mr. Montague-Smith, that search terms is a later stage in the exercise?
Yes,
and you haven't got the first stage off the ground yet. Not
yet, but what
I understand you say it's imminent, but
it's imminent, and there was discussion between the parties. And my learned friend says in his skeleton argument there was agreement to slow the pace of disclosure. To say,
yeah, I understand that. What's trouble? I'm sorry. I understand that, and that there's obviously WP negotiations that I can't get involved in, and one can understand if there were serious settlement discussions, one wouldn't want to incur lots of unnecessary expenditure. I understand all of that. I'm slightly troubled from the court's perspective in that we had 2 earlier CMCs, both of which were cancelled because the parties agreed. I don't think any indication was ever given to me as to why they were cancelled.
Because the claimants requested it, is why. The claimants asked that they be cancelled. That's why. So it's not consistent with the picture that's been painted. Now, can I just address the point about progress, though? Because the point about progress, my learned friend makes a big play to say, well, the solicitors have to get in all the data But it's not possible. It's never been contemplated that we would harvest literally all of the data of all of the defendants. It's got to be limited to the custodians.
Sure.
It was ever discussed that. So we have to get to a landing on custodians. And there is another discrete issue you may have seen, which is about a sampling exercise in relation to client data. We have to get to a landing on that as well. Now, in relation to the sampling exercise, we had understood that that was agreed. And so we got so far as discussing how the parties were going to select the clients who were to form the part of the sample. And then we get this letter last week, which says, no, we've decided not to do sampling at all. So we don't.
I don't understand sampling at present, Mr. Montague-Smith, because when it comes to quantum, I should have thought sampling is inadequate.
But we won't get the quantum data. We're not going to reverse engineer the quantum data from the client end of things. The way it works is that the company gets a retrocession, and it does not even have the visibility of the breakdown as between the clients in terms of what the revenue is that's being produced. So you're never going to see a set of invoices, for example, that go from clients to the DIFC entity. That's not how it operates. You're not going to interrogate the client data for quantum purposes. What we propose in relation to quantum and what the claimants told us they were considering was specific requests for disclosure in relation to quantum, which is likely to come, if anything, from the Avalok system that exists, as I understand it, in Switzerland. So you're not going to create the quantum process by going through literally every client relationship, all of the client data. If one thinks about the sheer volume of that data that there is, to search through that for what? You won't find invoices. So what are we looking for? That's not the exercise.
I haven't thought this through, Mr. Montague-Smith, but identifying who has been poached, putting it in crude terms, first step. If established, you then have to say, presumably, well, what is the value of that relationship, and therefore what the loss is? Well, that requires looking at each individual in some way or another, doesn't it?
Well, in terms of, that's not how I understand the case is put. Well, the way the case is put is that there was a systematic fraud. All of these clients were poached. So to get to your apportionment position, you'd have to reach the conclusion that some of these clients were poached and some just happened to come across through their own independent devices. That's
quite possible, isn't it?
It seems unlikely from my perspective, but even if that was right, you're not going to find that apportionment information down at that level. You'll find it in the Avalok system at the Bank Sarasin level in Switzerland, as I understand it. That's right, I think. And I apologise. I'm going to look at my instructions.
Yeah. No, I'm just trying to see what the structure of this might be. I mean, if both sides are in the all or nothing position, then it may be sufficient to do a sampling exercise to see if poaching has taken place. And then if it has, are you then going to accept that everybody's been poached and that your Avalok system will reveal all the revenue concerned?
I don't accept that. No, right. I don't. But I take your point, but it seems to me that if you were to find, for example, one inappropriate communication between a board member and a client, that would not in itself, and you were to say, well, that led to that client moving across, and somehow that's a breach of fiduciary duty, and there's a conspiracy in relation to that, then I can see how that might work out. But I think the primary position is that you're not going to get in a meaningful way the quantum of the value associated with that one relationship from communications between client and the claimant in any kind of structured, sorry, the defendants in any kind of structured way. Where you will find that is by interrogating the Avalok system in particular in defined ways. And we've proposed that we've explained this information as I understand it, and proposed that that is dealt with effectively in a slightly separate way through specific requests. Otherwise, what you're ordering is a vast amount of data, every bit of data in relation to all 400 of these clients, and then we really will be off the rails in terms of the timing. I'll come back to the timing and I'll explain where we are and how long. We've got an update because we have been going to various different providers, and we have rather more optimistic updates and shortcuts have been found.
Well,
so,
in a sense, Mr. Montague-Smith, I'd much rather go to that than go back over all the reasons for why we are where we are and who blames who. But I mean, I take the point about search terms and I take the point about custodians, but it doesn't seem to me that you couldn't have got on with getting a setup in place and putting up those who are obviously going to be custodians.
That might be right.
Get the thing on the move.
Well, I think we are taking our instructions or our information from the service providers. And as I understand it, it was agreed that we would not do that as between the parties. Now, the court may not be satisfied with that explanation as from the parties, but you know, if the question is whose fault is this, and I frankly agree with you in a way, I can understand why the court wouldn't be terribly interested in getting into the weeds of that, particularly when a lot of it has to do with WP discussions and the like. It's just you've heard a lot from my own friend about how it's all dreadful and how this hasn't been done, and that is not consistent with the way in which the parties were interacting along the way, and that is problematic because what it means is that the defendants can go into those meetings, but they can't come out of them really having confidence in what has been in the progress that has been made. It is counterproductive because there is this about face that comes subsequently when the barristers get involved effectively, and so you've got this backwards and forwards, and it's counterproductive trying to move things forward. The suggestion my learned friend said was that he's getting on with stages 3 and 4 of his disclosure exercise, or his client is, but without search terms, it's very difficult to see how that is even possible. Everybody knows that you've got to do the search terms to produce the volume of documents, which are then subject to review. I think my learned friend originally suggested in his EDQ that he was going to do that in a manual way. So we're going to have teams of people page turning. We've always suggested, and I believe that this is now also the claimant's position, that there is going to be a technology assisted review at that stage. So in order to make that work, you need the full universe of documents for the technology assisted review to be properly undertaken. This is something obviously that your lordship and I have experienced in the SCAT case. It works quite well, but it is a process which needs to be done properly with as many of the documents as possible to make that process and the learning process accurate. But the important thing is, we say, to make sure that we get directions which, if possible, well, they have to be directions which are workable. And I mean, my own friend's idea that we're going to get to the 9th of November and be able to actually undertake this process. I mean, his suggestion is that in order to get to the end of search terms, we're going to have a hearing sometime in the middle of October. Now, in my submission, that is not even reasonable. It's not likely that we're going to even be able to fix a hearing at that point. But that leaves what? That leaves 3 weeks before the 9th of October. So sorry, 9th of November, during which people then have to take those search terms, run them through the system, and then undertake that manual review. Or alternatively, the technology-assisted review of the documents. Now, he says he can do that. You may have a view on whether that's realistic or not. We rather doubt that they could do that. But their position is much different to ours, because they're dealing with a single entity. The data has been harvested during the liquidation process. The 2 terabytes, by the way, that my learned friend talks about are 2 almost identical hard disks of 1 terabyte each, whereas we will have a significantly larger volume of data that needs to be harvested. My own friend said, oh, well, the number of custodians are comparable. Not if he gets his way. He's looking for about 80 custodians as opposed to his 31. And obviously, the more custodians there are, the more data there is, the longer that process is going to take. But let me try and tell you about where we've got to and actually the timings that we anticipate.
That's what I want to hear.
Yeah. So step one is to move all the data onto servers. Now, my own friend picks it up in his skeleton and he makes the point today. He says this is part of a policy. He contemplates it's imposed by lawyers. But this has always been part of our requirements. They've known about this forever. He's right that it is the result of a policy, but that doesn't make it voluntary. These are regulated entities. This is their data security policy. So they can't just pick up and put down a policy. And my friend says, oh, well, there's no evidence of this, but they've never challenged this or argued about it before. So what has happened is that we have been in talks with 3 different providers since May. 2 of them are Big 4 accountants, and we are hoping that one of them will be appointed today. And can you tell them who it is? We don't know yet whether it's going to happen. If it is them, and we hope it is, and we're confident that it will be, they have a server which is currently available in Switzerland. There is also one in Dubai, which is currently available. So it doesn't need to be procured, but it does need to be cleaned of data. The Dubai process for data cleaning will take 2 weeks. However, the data extraction process, which is required in any event, can run in parallel during that period. So no time will be lost as a result. Sorry. Yeah, so the Swiss one, the Swiss server is already on the bank's premises in Switzerland. So the timescales we have are coming from the provider. We are not simply making these up. So for the data processing end of it, we are told it will take 3 weeks to retrieve and extract the data in Switzerland. And it will be a similar period in Dubai, but there will be 1 additional week that is required. Now, the precise technical reasons for that, I do not understand, but I understand it is to get around the bank's security systems, which, and I understand that 1 week is from experience. That is from the client's end, as I say. So that we are with that bit of information. The additional week in Dubai comes from the client end, but it's from their experience of how long it has taken to do a similar exercise in the past. So
well,
the bottom line.
I'm sorry, Mr. Montague-Smith, you confused me. First, you were talking about the Swiss server being in position,
Yes.
the Dubai server being available after 2 weeks, because it can both clean up and harvest at the same time. And now you're talking about 3 weeks plus an extra week in Dubai. Now, which is the position?
So it will take 2 to 3 weeks for the upload. That's the thing. So we've got the Swiss position. Basically, if we didn't have to do the installation process to get around the security, it would be the same, because we can start as soon as the provider is appointed. The cleaning process in Dubai can be run in parallel with the data extraction.
Yeah.
So that cleaning process doesn't add any extra time. What adds extra time is the getting around things in Dubai. So and the upload will take 2 to 3 weeks. So it's going to take 3 weeks to retrieve and extract the data in Switzerland, 4 weeks in Dubai because of the extra week. The upload will then take 2 to 3 weeks. And then the processing, indexing, OCR, deduplication, all of that will take another 2 to 3 weeks. So the total to get to the application of search terms is in Switzerland 7 to 9 weeks, and in Dubai 8 to 10 weeks. All of that, save for the 1 week in Dubai, are estimates that have been provided by the service providers. The 1 week in Dubai being the integration with the security protocols, and that's from experience. So if we started today, that takes us to the 2nd of December. Now, the reason there is a range is because it depends on the volume of data that we are dealing with, which in turn depends on the custodians and sampling. But obviously, now that takes us to the 2nd of December. Actually running the search terms should be relatively simple. It's been explained to me that it's an overnight process. Now, whether or not it can actually be done in 24 hours or whether it would require 2 days, I don't know, but it would be quick. Not something, given the ranges, that will materially affect the final outcome. But then there is a need to do the final further review of these documents. Both parties expect to be doing that review. It's not simply a question of just taking the search results and dumping them on the other side. There would be, potentially hundreds and hundreds of thousands of documents. And as I mentioned, it initially looked like that was going to be manual by the claimants. But everybody agrees now it's going to be a technology-assisted review. But the software needs the full set of data to be able to learn.
Can you just help me on this, Mr. Montague-Smith, in my ignorance? When one talks about a technology-assisted review, can you tell me in practical terms what that really involves? I'm sure I had it all explained to me more than once, but
I hope so, and it's been explained to me more than once, but I may be in the same position as your lordship. So as I understand it, the way it works is that there is the technology will produce a sample of batches of documents. Those samples will then be reviewed by live people, human beings, who have knowledge of the case and can therefore identify documents which are, we say, in 3 categories: relevance, privilege, and then also sensitivity to these Swiss and international restrictions. I'll come back to that in a moment. And then what happens is they feed the results of those reviews back into the algorithm, and that then produces a new sample. And then it's re-reviewed, and the turnovers are logged. That is, turnovers as in disagreements between the human beings and the machine. And it only takes a few iterations of that, and eventually they come out clean, and then we can move on to the next batch. So it is a process which speeds things up very significantly from a manual review, but it is not. It still takes time.
So my understanding that is pretty much as I thought. You take a number of samples out and do a manual review and feed it back in again, and then it's applied across the whole. But how long is that going to take in the present case? Best guess. And I know we don't know how much there is originally and so on and so forth. But
so one of the service providers that we have been, again, this is not information coming from the client. This is coming from one of the service providers. Their estimate was, if you took, say you had 40 custodians, and if you assume that you have 5,000 documents for each custodian, that builds a volume of documents of about 200,000, which need to be reviewed in this way. Their best estimate is that would take 2 to 3 months to do. So 200,000 documents, 3 months, 2 to 3 months is the estimate. The difficulty with these things, my learned friend says repeatedly, my clients are well resourced. There's a relatively tight team running the case. Of course, one can always pull in bodies, but then so could Holm and Fenwick pull in bodies. But if you don't have people who are actually involved and have information about the case, you build in problems to the process, and it takes longer anyway. It is also one of those processes that has diminishing returns the more bodies you throw at it. So, for example, in the SCAT case, that whole process took well over a year to complete, because even though one can't really think of a better resourced case than that one if one looks at the trial that's going on in London at the moment. So that ultimately is why just looking at this realistically, we're looking at a disclosure date in February, really. And the date that we have suggested, I think, is the 10th, right, February. Now, that, look, your lordship has an option. I come into this late. I look at it and I think, what would be the sensible approach here? Is it to say, no, let's keep you to 6 weeks. We know you're not going to make it, and be down with the consequences, or is it actually to reset, as we had understood the parties had agreed would happen, and fix a date that is actually realistic? This is not a date that we really have much control over in terms of bringing it forward just through sheer effort. If we start today, we'll end in February. That's realistic, we say. But it does depend on a degree of proportionality when it comes to the identification of the universe of data. Now, I think on the letters rogatory, if I can just deal with that very briefly, my lord. I mean, it may be that there is not much for you to do on that today in this sense. Just to remind your lordship, our understanding is that there is a very real risk that there would be a risk of prosecution if certain types of document are produced. Now, the claimants say they doubt that, and they put, my own friend says, I spent a lot of time on this in my skeleton argument. He's gone into it in quite some depth, but I'm pleased to hear him say that he doesn't think we can deal with all of that today. Now, what I'd taken from the previous CMC, what I understood, was that everybody realised that you need to get through the disclosure process first, effectively produce a log of documents which may be caught by this, and then have the discussion and, if needs be, the argument at that stage. So you're not going to be looking at things like waivers. My learned friend says, well, this isn't going to arise because there are contractual waivers in some of the contracts. That's the point that he made first in his skeleton argument on Friday. We've not seen that point before. We don't think it is right. If it was right, that would be great. It would save us this headache. But we don't think it is right because it is specific to documents which are available to BJJ SAM. And if they're available to BJJ SAM, they'll come out of the Dubai end of disclosure anyway. So the other thing my learned friend says is, oh, well, we can just make an application to the Swiss court, and he gets that from the expert evidence or the evidence that's been provided. We don't find that actually in the evidence, but we can look again at whether that is a way around it. Fundamentally, we think it is right that limited relevant documents should be caught by this, because you're talking about the winding down of a DIFC entity. Now, of course, it said there's involvement from Switzerland, but ultimately, the claimants will need to demonstrate that unlawful means were used to, for example, divert clients. And that's going to require, we say, at the least, some unlawful conduct by officers of BSA to found that central unlawfulness that they assert. That the mere movement of business from one entity to another, the mere procurement of that movement of business by one person to another, is not in and of itself unlawful. What they need to look for, what they need to find, is some unlawful conduct, and that is the breach of fiduciary that's alleged. So ultimately, it is DIFC activity which should be at the centre of this. But we can't resolve this until we know what are the documents which are going to be required and which may be caught by these foreign law provisions. We know that there needs to be specificity, granularity in that letter rogatory. And so the way it's going to have to work is we're going to have to get to the end of the disclosure process, produce a log of documents that we say, we think we cannot produce these, make our letters rogatory requests and hope for the best in relation to those. And in the meantime, have a discussion with your lordship about what happens if we aren't able to produce those documents. Now, I had understood that that was my learned friend's understanding of the proper way of doing this, and I picked that up from the I'm afraid, the transcript of the last case management conference. And I'll just show you a very short passage of it, because this is what we were working from to some extent, or at least this is consistent with our understanding. You go to page 2103 of the bundle.
Sorry, page again, 2013.
Sorry, 2103.
2103, yeah.
So your lordship, in the middle of the page, you're discussing the need for a proper hearing, proper evidence, and as my learned friend referred to, what he just described as sort of Bank Mellat issue. And you say, if this is what's going to happen, then the hearing must be properly prepared for, and material must be before the court so I can make a decision. If you skip down to Mr. Shivji's response below, he said, we set down a day, my lord. Just on your lordship's point about the risk of prosecution, I mean, there's a few points. Actually, the way that this normally works, as I understand it with Swiss institutions, is they run a standard disclosure exercise so they can identify the list of documents that are responsive, and then the application is made to the Swiss courts under the Hague Convention that identifies the material that has already been found as part of the search. So it's not some roving order where the Swiss court simply makes a non-specific generalized order. The exercise is done, and then they get the validation through the Swiss courts to produce the documents. So we do not see that as a barrier. So that I think has to be, and we thought that was agreed. Mr. Shivji said something else today. He says he wants our letters rogatory in 4 weeks or something before we've actually done the exercise. But that, we say, is clearly the most sensible approach. Now, it's been suggested that there might be multiple letters rogatory applications that could be made. We don't think that is the right approach, because we're told that if you keep making applications to the Swiss courts, they're more likely to be turned down. There was some suggestion we might be hiding things from them in making these applications, but actually the application is made through the courts. So we have to apply to the DIFC court to make the request to the Swiss court, who then deal with the request, and then it's transmitted back again. So there's no prospect of hiding anything. Another unwarranted suggestion. So ultimately, your lordship may or may not agree with us that the documents simply cannot be released without the conclusion of that process. But we obviously need an opportunity at that stage to deal with the point, using expert evidence if we need to, and to explain why we cannot produce those documents. And if the rogatory process cannot be completed, if it can, then everything is fine. If it can't, then your lordship, we say, just can't simply accept the claimant's assertions that none of the documents are caught by this. We need a chance to explain our position. And once you're faced with that list of documents, it's really only then that you could make the decision as to what to do next. You'll have a range of options, my lord, that are available to you, from case management options to proceeding without the documents, to deciding whether or not to draw adverse inferences and the like. And all of that is discretionary. All of that is on the cases granular and requires you to look at, essentially, the log of the documents that are being withheld and decide whether or not that there is a good reason for that. Now, we could, of course, just barrel into trial, and you will have section 1 of the other side's skeleton argument will be, well, draw all these adverse inferences because they haven't produced these documents. But the better approach, we say, is to anticipate now that there is very likely to be debate about this in due course, and probably, and it can only really be after we've gone through the disclosure process that I've just described. The claimant's approach to this to date has been just to say, well, that's the defendant's problem. We don't really care. We don't object to them doing it. How could they? But it's their problem. If they can't solve it, then that's their tough luck. That's one response. We say that's not the fair response, because if we're right, then there may be, we don't know yet, a category of documents that the defendant simply cannot produce because there's a real risk of prosecution. And in those circumstances, there will be points to make about how your lordship should approach this, and there may be rather more fundamental questions for this court to ask itself about whether or not it adopts the English approach at all, lock, stock and barrel in relation to this. And certainly there are shadows in other cases in which the English approach to unlawfulness abroad has not necessarily been wholesale adopted, given the international nature of this court and given the likelihood that these sorts of issues will arise on a regular basis. But there is a debate to be had, is all I'm saying. It's not going to be had today. When is the time to have it? It's got to be at the time when we know what we're dealing with. So at the moment, our position is that once that disclosure exercise is complete, the defendant should be required to produce, firstly, a privilege log. And we know that there will be arguments about privilege because the claimants have said they're going to be. Secondly, a log explaining the documents or categories of documents which are affected by the local disclosure restrictions and in respect of which letters rogatory are to be issued, and then production of the rest of the documents. We've devised it in that way simply to ensure that it's not said that when we produce that log, literally the next day, because we have produced a log and not the documents themselves, that's it, we're out of time and it's too late to do anything about it. So that is how it's drafted in the draft order that we've provided. That is, we suggest, a sensible and fair way of going about this and of giving your lordship what you need to decide what to do about these documents. My lord, so that's the shape of what we are proposing. Yeah, it is drafted that way at 20 and 21. What about the list? That's one. So my lord, that's what we are proposing to deal with. There are a number of issues in relation to how we get to that point, search term, timetable, custodians and the like. There's a little bit of difference between us about the mechanism by which the parties agree to search terms. But I don't know whether you've got any questions for me at this stage about what we're proposing.
Well, I'm just looking at your draft order, and I'm looking at 21,
Yes.
22.
I mean, it's certainly not, and so it's certainly not anticipated that you make a decision from our side, that you make a decision on this issue in advance, so to speak. So it's got to come back to you at some point.
No, what I'm looking at is the overall timescale.
Yeah.
Mr. Shivdin never answered, I think, my question about what the minimum time required would be from the completion of disclosure to trial. It seems to be almost inevitable there'll be specific disclosure issues that will arise that will have to be dealt with.
Well, thank you very much.
Depending on what happens in relation to information, documents, and so on that's required for letters rogatory, who knows what time will be taken with that, and then the whole business of simply getting witness evidence together. And expert evidence. I can't quite remember what the position is on expert evidence, but there's plainly going to be some forensic accountancy evidence.
And some law evidence, I believe.
Oh yes, of course, yes, possibly, yeah. So the question, you haven't made an application for an adjournment, and I don't want to grapple with it unless I have to. But the idea that we might be faced come March next year with disclosure applications and other issues which would impact on a trial date.
Yes,
not obviously a possibility.
I think you're right. I think we're sort of dealing with what's in front of us at the moment. But I do, and I come to this without any agenda or indeed any instructions about the trial date, but it does seem to me that the sensible approach is to take a realistic look at all of this and work it out. My clients have got no particular wish to push this down the road. That's not what's happening here at all. There were genuine attempts to settle. That's not happened, and now we crack on with it. But if the answer is that this is not going to work, then I can see the sense in taking that by the scruff right now. It's better to look at, one can see, I mean, if you were to push it back by a couple of months or something like that, it's much easier to do that now than it is in 6 months' time or 9 months' time. That's all. I mean, maybe they'll be driven by your lordship's view to some extent on when. I mean, if you agree with Mr. Shivji, then we'll just have to. I mean, frankly, there's probably nothing much going to come from us on the 9th of November. We will try, but there won't be much. But if you were to push it back and say, actually, look, realistically, disclosure has to go back to February, and that's the position that we see that we are in. Then it may be that the claimants take a different view about whether actually they want to shuffle everything back rather than maintaining the trial date where it is. I don't have any instructions. That's just me making my observations in an attempt to be of some use. I mean, the other point to make about this, just on the 10th of February point, is that timetable is dependent on us starting today and probably starting to import custodians within the next 14 days. So in that regard, we do need a finalised set of data.
Yeah, well, we can discuss custodians today and get most of that sorted, it seems to me. I can simply make some decisions on that.
Yes.
So custodians ought not to be a problem.
Subject to one point, my learned friend wants information about other potential custodians and therefore trails the prospect of applying for further custodians. That's number one. And number two, he has 14 custodians who he has identified, but the application for whom he wishes to defer until a later date. And so he doesn't press them today, but he says he wants to retain the right to add them as custodians at a later date. So there is a shadow, well, there is more than a shadow, there is a prospect that the claimants will be saying subsequently, thank you very much for your list of, we say 40, they say 80, but now we need more. We need to add another 20 for this reason or that reason. And all I would seek to impress on your lordship is that all of that needs to be done once. Now, of course, there may be specific disclosure applications in due course that can be dealt with on their own terms. But both parties, all parties, we would suggest, ought to be approaching this disclosure exercise on the basis that it's the intention, at least, is that this be done once and once only, and therefore that we do it all and get on with it. And part of the problem is at the same time is trying to sort of hold our feet to the fire. My learned friend is trying to expand the universe of data, the number of documents that we're dealing with. So he's saying we should do it in half the time, but with double the amount of data.
Well, what are you saying to me about the position, the reality, if I was to accede to your request to push back disclosure until the 10th of February 2025? So that's your paragraph 21. What are you saying to me is the future progress of this action if I order disclosure by 10th February 2025?
I'm sorry, I'm just looking at the case management order that your lordship made. So 10th of February, at the moment, Witness statements are due on the 7th of March. Sorry, so we're looking at page 430 of the bundle, which is the relevant case management order from previously.
All right, let me get that up as well. I'm simply looking at the draft order at present, but what did you say, 430?
430 is the relevant part of the existing case management order.
Oh, right. Well, I've got that in hard copy somewhere, which is the 20th of June.
I will take, yes.
Yeah, witness statement 7th of March. That was 4 months after completion of disclosure, and it's hard to see how realistically it could be anything less, isn't it?
Well, one can squeeze it. I can see that, but I tend to accept. I think I have to accept that if everybody is exchanging documents on the 10th of February, preparing witness statements on the 7th of March is going to be difficult. One could see it being done in 2 months rather than 1. Expert reports will also need to be in train. So you'll see at paragraph 16 the step that was agreed and ordered. Valuation experts shall meet to identify documents that they require and the methodology for their reports. Now, it may well be that will be affected by disclosure. I can't tell you that I've got any input from a third-party expert saying we're going to need X amount of time.
Well, as a matter of preliminary thinking, and parties must have applied their minds to it, even if I haven't. How does one set about a valuation of this kind? I think I probably had a discussion with Mr. Shivji about this because in the context of my suggestion the parties ought to get together and try and settle it, but I can't recall whether he explained how he thought damages would be quantified. Maybe you can help Mr. Shivji on that.
I can, my lord. I mean, there are a number. So the answer to that is that there is both a damages claim and also a claim for disgorgement of profits, and we can elect later as to which we want to pursue, and we'll obviously go for the larger sum. That's one of the reasons why we need proper disclosure for the 5th defendant, including of its trading profits after the date of acquisition of these clients. In terms of the valuation of the business, there are various valuation methodologies, and ordinarily forensic accountants or sometimes corporate finance bankers can give evidence on that. And there are, as your lordship probably knows from other cases, a range of different valuation methodologies, whether they're based on assets under management or profitability or revenue measures or sort of more sophisticated modelling. So I suspect, my lord, it will be that sort of evidence that your lordship hears on that point. But
actually, that is the point I'm driving at here is that, from my experience of these things, I'm not certain that detailed disclosure is going to make a lot of difference.
It will do on some of it, my lord, because of course the inputs are the performance of the business as it was, and as it was originally in BSA, and then as it was in the 5th defendant, and so that but
that'll be essentially based on the accounting documents rather than on anything else.
Well, there was your lordship's point there also about the clients who've been poached. I mean, Mr. Montague-Smith started by accepting that if we managed to establish one case of poaching, then all the other clients fell away. Then I think he realised the consequences of that, and quite rightly for his client, I think, rode back and said they'd have to argue on causation.
That's not what I said.
But my lord, the point is there's a causation point to be established in relation to these causes of action, and that will have to be established on a client-by-client basis. So, I mean, we'll come to sampling in a moment, but this is exactly why my learned friend's sampling formulation doesn't work, the court will ultimately need to establish in this action which of those clients were poached and what the financial consequences were for each client, and that will then go in to an assessment, both the loss of profits and disgorgement of business. Disgorgement of business. So, my lord, does that help with your question?
Well, again, I'm looking back at that. I'm looking at the timings of this in broad terms. We're looking at that earlier case management directions.
Yes.
We were having witness statements 4 months after disclosure.
Yes.
We're having experts reports 2 months thereafter.
Yes.
Is that right? No.
Yeah, yes. that is right, my lord. It's 9th of May.
And then supplementals a month after that.
Yeah. And our submissions. I'm sorry. I'm sorry that I didn't answer your question fully earlier, but I mean, in terms of the gaps, we think these are sensible gaps, and I would be very reluctant to squeeze them. You know, this case having run off track already right at the beginning at the disclosure stage, I would be very nervous and saying, oh well, one can compress this timetable if
understand that.
So my submission would be that the gap should remain the same. Can I also just point out that there is a fundamental difference between this order that the court's ordered and what my learned friend is asking for, because he wants you to bifurcate the letters rogatory disclosure from the non-letters rogatory disclosure.
Yeah, no, I've got that point. Don't worry, I've got that. I've got that point, Mr. Shivji. But on the face of it, as it was originally envisaged, there's 8 months going on to paragraph 20 as it was. There's 8 months for completion of witness evidence and expert evidence following disclosure.
Yes.
Right.
And in my submission, that is an appropriate time, bearing in mind that they're inevitably, I mean, as your lordship has seen with the history of this case, we're often before you. It is always productive when we are, and when we're not, things tend to go off the rails. So I think we would be very keen to maintain that and bear in mind that there may be hearings along the way to police the adherence to this timetable. And our strong suspicion, I must say, some of the things that my learned friend said today about their disclosure exercise and what we may get at the end and what we may not get rather filled me with dread. I mean, no criticism of him, and I know he's doing his best without evidence to tell us what he's been told by his clients and third-party disclosure providers. But it is rather difficult, we say, to proceed on these sorts of applications where all the evidence is coming through submission. And it does cause us worry later on that there will be arguments about the integrity of this process. Even the description of how the TIR process would work, which is not something that's been agreed, is a cause of concern. So this is all going to have to be scrutinised quite carefully.
Right. Well, you'll have your chance to reply in a moment, Mr. Shivji, but what I was looking for was to see how it pans out. Now, Mr. Montague-Smith, if one looks at 8 months and adds that to your 10th of February, we find ourselves on the 10th of October with a trial on the 27th of October, isn't it?
Yes.
Yeah. Now, what do you say about that? Do you say those periods can be foreshortened? And what do you say about letters rogatory fitting into that? And any arguments that, or unforeseen contingencies and other applications that may emerge on the way?
Yeah, and I hear what you say. I think, what do we say about can they be foreshortened? Yes, they can, clearly. You cannot bully data onto a machine faster. One can prioritize this case over others when one's preparing witness statements and all the rest. But so yes, I do think that 8 months can come down to something more like 4 months. That is possible. That is one option. What we just have to bear in mind, though, is that the estimates or the timescales that I've been giving you are data dependent. And if the answer is that your lordship thought you were making a disclosure order of that, giving that amount of time for disclosure in relation to the sort of universe of data that we're now talking about, I'd be quite surprised, because we may well be dealing, if we double the amount of custodians and double the amount of data, we may well be dealing with not 200,000 documents, but more like 500,000 or more documents. It's very hard to know at this stage. So we are already in the sphere of a very detailed document, an unusually detailed document disclosure process for this court. Not unprecedented, I accept. But if we're going to keep this on the rails, we have to recognise the limitations that need to be imposed on the data that is to be used. So I do accept that if I'm wrong about some of those points, who are against me on some of these points that we're about to discuss, there is good chance that it just will take longer in a way that is not within our control as the defendants. And if that happens, then the trial date looks in jeopardy. In terms of letters rogatory, my position, I thought I'd explained, but it may be that it was misunderstood, was that the way it normally works, at least in England, as I understand it, is you do your disclosure exercise, you produce your...
Yeah, no, I understand all of that. If one allows 3 months for letters rogatory, and that may be slightly ambitious, but if that then takes place, the question is, at what date does that process begin?
Well, it can only begin. It can.
Well, I appreciate can only. There's a point before which it can't, but is there a point at which it can in reality begin following the 10th of February?
I don't think we've got too many I mean, that is just lawyer work, is it not? To get it together.
I should have thought so.
You're my instructing solicitor, but I would have thought to. Sorry, that's not the question that's being asked.
No, the question that you are being asked is really this, Mr. Montague-Smith. There you are, getting on with the process of disclosure. By the 10th of February, you have not only given disclosure, but obviously analysed it to a significant extent.
Yeah.
You're going to produce witness statements in a period thereafter. But what is the time at which you will need to go for letters rogatory?
To make the application to the DIFC courts within 2 weeks?
No, almost the same time.
A week. Well, I mean, it will be about the same time because we'll know in advance, won't we, what we've got. So, I mean, if you were to give us an extra 7 days or something after that, just to...
Right. Okay. Then so far as letters rogatory in relation or getting permission for witnesses is concerned,
yes,
how does that fit into the timetable?
We have to do that at the same time. No, later. Well, I'm being told later. I mean, the problem with that is that we need to have the witness statements, as I understand it, to make the application.
Yes.
So
that's exactly my point. And as matters currently stand, we're talking about 4 months before the witness statements come.
Yes.
Starting from the 10th of February, which takes us to the, whatever it does, 10th of June. And then you've got to do your letters rogatory.
Yes.
Now, if you foreshorten that to 2 months for witness statements, which seems to me pushing it some, you're still talking about 10th of April with a letters rogatory process beginning then.
Yes. The prospect of
doable?
Well, it's not in our hands.
Is it I realise one has to take some sort of view about this, Mr. Montague-Smith, in the light of the unknowns. They say the known unknowns and the unknown unknowns, but
I know.
Look at the known unknowns for the moment.
Yes, I mean, so to give you a sense of it, I believe a similar process was used previously, and it failed. And the failure came back something like 8 months after it began. So it's very hard to explain. But one would have thought if it's going to be successful, then after 4 months, perhaps we will know. I don't know. I'm afraid it's the finger in the air for me. Sorry.
It's a process upon which nothing else depends, so to speak, except the trial. None of the other steps, the experts and so on, won't depend on this.
Yes, that's right, is it not?
That's the way I see it at present.
At present, that's the way I see it too. It's my understanding.
Sorry, Michael, do you mind if I interject on that? Because I'm not sure that we see it like that. As I understand, this is client data, and we are as I understand,
I'm talking about witnesses at present, not client, not data.
Fine.
No, I understand the possibility that expert evidence may depend upon what's disclosed, but we've already had that discussion. But in terms of witnesses, it wouldn't appear to be.
No, as I understand, the witnesses, we will be given the witness statements at the point of exchange, and they are simply getting permission for the witnesses to then give evidence at trial. So, as your lordship says, it drives the date of trial for that reason.
What happens to the witness statements if no permission is given?
Well, again, a view will have to be taken as to firstly, whether or not you accept that the result of that is that the evidence, if it was given, would result in a real risk of prosecution, and then you'd have to take.
Then we have the Mellet discussion and so on and so forth, debate and whether or not these, what happens next?
Yeah, I mean, we would hope that we would get the clearance we need to do that, or if possible, find some other way around it. If that is possible, but if it is not possible and we cannot put up these witnesses, then my learned friend will immediately say, well, draw some adverse inferences, and we'll have an argument about it. Right. That will have to be phased in as well. Yes.
All right. Is there more you want to say at present about the timetable through to trial, so to speak?
Nothing that I haven't already said, I think.
Well, can I give you my initial views on this subject, and then you can address me as to where we go from here. My initial view is that it is just possible that this trial date can be maintained, and I'm not therefore prepared to contemplate adjournment now, whilst recognizing that there may come a point where that nettle has to be grasped. I also think there is some possibility of foreshortening some of the steps a little bit. And I will hear Mr. Shivji about quite how that could be done and what he wants to say about the disclosure process and the dates by which that should be completed by way of reply. So that what I'm anticipating is that before we go on to deal with custodians and all the rest of it, we will be working towards the trial on the 27th of October and finding the best dates for a timetable that work towards that. So I hope that helps people in their framing of further submissions. I take it, Mr. Montague-Smith, there's nothing else you want to say, therefore, at this stage, and it's for Mr. Shivji to reply on what you've said about the need for an extension on disclosure.
Yes.
All right, Mr. Shivji, back to you. Where are we? We're 2 hours in now. The question is how long we anticipate being, having got to where we've got to.
Well, I think from our perspective, this is obviously an issue that needs to be nailed down today. I would be incredibly grateful if we could spend some time on custodians. I suspect we won't get through all of the custodians, but if we can at least tick some.
Well, I think we might.
I'll be very pleased.
I've seen what's said about custodians in both people who've produced helpful schedules at the back, and I'm not quite sure how many more I've got to deal with beyond those that appear in the schedules, the appendices to the skeletons.
Very good.
And you'll each want to say something by way of introduction. But my intention would be to deal with custodians today, to deal with everything that can be dealt with today. I say I don't have a problem of a further engagement later today, and I'm very happy. Well, I'm not very happy, but I will spend the time that's required I wasn't very happy to receive extensive skeletons on Friday night either, with the parties having agreed such an extension without, as I understand it, me being asked about it. But perhaps I've forgotten and I was asked.
I'm sorry about that, my lord. I wasn't aware of that, but that's obviously not very satisfactory. Just going back to your question about where we are now, I see that the court staff has just put up a note saying the transcriber needs a break.
Yes, well, I was thinking that.
Would that be a convenient moment before I come back?
And you can perhaps, between you, work out how long you think we're going to need after the break.
Very good.
But from the court's perspective, and we're still relatively early in the day, aren't we? It's 10 o'clock London time, so it's only 1 o'clock in Dubai. So we shouldn't actually have a problem providing, within ordinary court hours in Dubai, should we?
No, I hope not.
I would hope. Let's take a quarter of an hour break now, and you can consider what submissions you need to make and tailor them in the light of what I've said.
I'm grateful.
All right, thank you very much.
Thanks.
A quarter of an hour takes us to, well, let's say quarter past the hour.
Very good, thank you.
My lord, Mr. Shivji and I failed to have the conversation you asked us to have. That's probably my fault because we turned the camera off too early. I would expect, unless he disagrees, that between us we may need another 2 hours for this.
I think that's right. I'm afraid, if that's convenient or if that's acceptable, not convenient, Your Lordship.
Well, it's all right by me. It's rather more difficult for the staff in Dubai who might be thinking of lunch.
Is there a possibility for having? I mean, perhaps we can get this point on timetabling out the way and make a bit.
Well, I'm sure we can accommodate this. The only question is whether we're going to need a more sustained break for the staff in Dubai. So if Lena would like to send me an email saying what works from their point of view, then that would be helpful. And otherwise, you carry on until I tell you to stop.
Okay, very good. Well, we'd be content. I mean, it may be that we can just sweep the timetabling points out the way and then have a break before custodians, but I'll leave it to the court staff to decide what they would prefer. So, my lord, just coming back to my learned friend's submissions on the timetabling, as I said, I mean, no criticism here at all. I know he's doing his best, but the information that we got today about where their process is, obviously is not reflected in correspondence. The timing is actually quite different to what was put out in his skeleton and correspondence. And it does put the court in quite a difficult position because the court's being told this is the best they can do. But essentially, the court's been given a fait accompli without either the claimant or the court being able to drill down as to exactly what assumptions these estimates are built on and whether there is scope for speeding it up. And I say that in particular in circumstances where it appears the defendant hasn't decided which of the big four that it wishes to choose, or if it has, it's not willing to reveal that today. And so we don't even know from the horse's mouth, from the person who's actually doing the exercise, what precisely their estimate is, and whether actually if more resource is thrown at the problem, whether it could be speeded up. But I think for our part, the timescales that they're talking about for harvesting, uploading, processing are pretty long actually, and we have been able to move much more quickly. So we are surprised at those timescales. Can I say this, that ultimately the court's really put in a difficult position where if it gives the defendants significantly more time, then it has the effect of prejudicing the time that the claimant has to prepare for trial. And that is why these applications normally are a matter of balancing the prejudice from one party against the other. Now, we also want to be as accommodating as we can. And looking at the order at 4:30, I mean, our view is that really from witness statements on, those milestones need to stay where they are or thereabouts in order to maintain the trial that your lordship has ordered. So working back from that, we think that disclosure of the disclosure probably needs to be completed, the whole exercise needs to be completed by the end of the year, which would be an extension of nearly about 7 weeks for my learned friends. And that would give them from now, well, the whole, that's essentially just under 3.5 months from now to complete the whole exercise. And we think that is realistic, even though they're only pressing the trigger for the starting gun now. Now that just raises the questions of the letters rogatory, and my learned friend seemed to suggest that that process might take around 4 months, although he said it could take longer, anything up to 8 months, I think he was talking about. That again troubles us because, of course, we do need to have all of the disclosure, seen it all, in good time ahead of the deadline for witness statements. And of course, in time for us to come back if we say that there's some omission in disclosure. So we think that the letters of request needs to be made by the end of October. And we think there is a way of my learned friends trying to make that happen. They should know at the very early stage which types of documents will be covered by what they say are the restrictions. And they should target all of those first. I mean, they may have to put them through an expedited process, a small expedited process in order to get your hands around them. But that should be targeted now, and they should be aiming to have those lists by the end of October, so the letter of request can go in then. And then on my learned friend's 4-month timescale, that would have a response by the end of February, and your lordship currently has ordered witness statements on the 7th of March. I mean, any later than that, and the date for witness statements is not viable. And what we can't have is essentially a sort of bifurcated process where one gets one tranche of disclosure on time and then another tranche of disclosure much later after witness statements, and then that means there needs to be supplementals, etc. That would be very unsatisfactory. So, my lord, we think that's a way forward. And I mean, lawyers often say things are different. One often has this when one argues about extensions. I remember when I started in practice in the winding up court, there was endless debates about whether things could be done within the time frame, and the court often just said, well, that's my order, you've known about this, you must do it in this time frame, and parties make it happen. So we say giving them 3.5 months is perfectly realistic, and giving them a month, just over a month, 5 weeks from now, for letters of request lists, that's also realistic. And then just turning to witness statements, as I understood my learned friend's submission, he seemed to be saying that there was no problem exchanging witness statements before the letter of request order is made by the Swiss court. I think his submission is that you only need the order for the witness to be called. But it would be good for him to clarify that, because as I understand it, I think as your lordship understood it, the absence of a Swiss order doesn't prevent the exchange of witness statements taking place. And that's quite important. If my learned friend is saying something different, he needs to clarify that, because again, that might disrupt your lordship's timetable. So my lord, that's our position. Try to do the best we can, and I mean, we are trying to be accommodating, and we are very pleased that your lordship wants to keep us on the current track for an October trial. We think that's the right order. Is there anything I can help your lordship with on that?
No, I didn't think so. Thank you.
My lord, I should just clarify a couple of points, because my other friend has raised them, if I may. Firstly, the service provider that we're not giving you is Ernst & Young. We haven't got there yet today, but we're hoping to get there today. Secondly, in relation to the letters rogatory implicit in my learned friend's submissions, he seems to think that this would not come back before you until that process was complete. That's not how I envisage it working. The way that I think I was proposing you would deal with this would be that we would have the discussion, essentially, once we know the list of documents, on the assumption that if we do not get through the letters rogatory process, you decide then and there what's going to happen as a result. And the letters rogatory process can continue in the meantime, if you see what I mean. And then hopefully it resolves, and then we get to the end of it, and then we can produce those documents. Yes, it means things coming in late, but there just is no, there's a limit to what we can do about that time scale.
Well, what was suggested there was that you could embark on your letters rogatory exercise at an earlier date during the course of your disclosure. that you could give priority to that.
Yeah, but that's not going to work at all. I mean, certainly not by October, because I've given you the timetables given to us by Ernst & Young. We won't be even putting in search terms by October. My learned friend doesn't even envisage us having search terms by October. He envisages a hearing to determine that in October, if the parties can accommodate it. So the way that it works is the more specific the request, the more likely you are to actually get permission to produce those documents. And at this stage, we unless we've got a list of documents, then we're not going to get anywhere. And as I've said, our understanding is that multiple continual applications just mean you are less likely to succeed. So the right approach, we say, and the normal approach would be to get to the log of documents caught by this at the end of the disclosure process, and then start that letters rogatory process, but have the discussion, if need be, depending on the nature of that list, if there is a list, with your lordship in February or March or whenever it can be scheduled, in anticipation that we don't get through that process. And if we do get through that process, then we can produce what we can produce. So that was what I was anticipating. But the idea that we should be, I mean, I appreciate my learned friend wants to squeeze the timetable, but I mean, ultimately, you know, we can't tell the data to move faster. And then in relation to witness statements, my learned friend has misunderstood. The position is not that we can produce the witness statements to my learned friend, but that we would need to, well, we need to prepare the witness statements and then put them through the letters rogatory process. So we would not be allowed to rely on them in these proceedings until that had been completed.
I appreciate you can't rely on them, so to speak, but there's no difficulty about serving.
Oh, I may have misunderstood.
That's what I'm asking. That's what I'm asking.
I apologise. Would you just bear with me for 1 second? And I apologise for the way this is going, but I'll just take instructions on that. Thank you.
Yeah, that's what I'd understood you to say earlier.
My apologies. I misspoke earlier. I'd understood that the letters rogatory process was an open process, and it isn't. And so what would need to happen is we would have to make, in effect, I don't know whether it would count as ex parte, but an application to this court to pass those documents and make that request to the Swiss court, which the claimants would not be entitled to see.
The court, not the court.
Nor the court.
It's a diplomatic process, as I understand it, Mr. Montague-Smith. So it goes through the Foreign Affairs Department of the DIFC to the Swiss, and it wouldn't therefore necessarily touch the courts at all. I think that's right. I don't think they come to the court to ask the Foreign Affairs Department in the DIFC, but I might be wrong about that.
I'd understood that to be the process, and I apologise that I don't have that at my fingertips. But
well, no doubt someone can look it up whilst we speak to make sure we're all looking at the right thing.
I'm told that the right approach is that we approach the court to make the request, and then that goes.
And the court then asks the Foreign Affairs Department, and it goes through that way. That would be the way it worked in the UK. But it's an ex parte application on your part, is it?
It is, and then we don't, and I'm told, I misunderstood, but we don't attach the witness statement, but we do need the witness statement in order to be able to make the application, because we need to explain in broad terms the topics that are going to be dealt with in it. Is that right? Yeah.
That seems bonkers. It would seem much more intelligent to provide the Swiss authorities with the witness statement itself.
Yeah.
Otherwise you're just going to summarise it, aren't you?
It will be specified what it is, so it will be drafted.
Yeah.
It will be finalised. We just won't be attaching it, but it will say provide the witness statement dated blah.
Right. So it will be yeah. Okay. So it's yeah. It's an application in relation to a specific and existing witness statement that needs to be made, albeit that witness statement is not attached to the application. That's the process. No doubt there will need to be justification and an explanation to the Swiss court so that they can take a view on it. But that is the process that I'm told is to be followed. So the result is that we need to have the witness statement drafted, but no, it's not going to be one that can be served until we get an answer to that process. So I think the proposal is, if and to the extent that these issues arise, they will have to be dealt with in separate witness statements. So the affected witnesses will need to give 2 statements. Is that right? Yes.
I'm not following this.
There will have to be 2 statements. One will not contain the sensitive information. So presumably there will be.
Oh, I see what you mean.
This is what to say. One will be served and one will not until.
Yeah, I see. I'm with you now. I've got you.
Sorry, I'm not making this much easier, I'm afraid, but I apologise for that. But anyway, that's the process that we need to go through. Beyond that, it's simply a question of us undertaking to move as fast as we can and doing so and keeping the court updated as to the progress, with your lordship's concern in mind that the timetable is fragile.
Well, I'll tell you again what I'm inclined to do, and you can make such further submissions as you wish, albeit shortly. I'm inclined to set you a date to complete disclosure that you say currently is unrealistic. I'm, in that sense, holding your feet to the fire, and we're going to make provision for further hearings so that the court can be kept updated and you can make such applications as you wish, should those dates in fact prove to be impossible, as you now say. But I think there's something in Mr. Shipch's point that very often when parties are ordered to do something, they can achieve it in circumstances where they formally said it was impossible. So notwithstanding all that you say on instructions, and I'm very conscious that you don't have evidence on the subject, and therefore when you have instructions, they are doubtless given with a certain degree of latitude for those involved, and possibly in the expectation that the court will cut short the periods concerned. So I'm going to fix a date for you to complete disclosure. And it's simply going to be as simple as that, for completion of disclosure by the end of the year, full stop. Now, how that works out in practice then, of course, is a matter for you. But I think if we work on that basis, there is then at least the possibility of all being sorted out.
Well, can I just ask a question in relation to that, if you're finished on that front?
Yeah, please ask, yes.
So, I mean, your lordship's aware that our position is, I mean, talk about latitude. This is coming directly from Young.
Well, I understand all of that.
Us. On current information, we will not be in a position to comply with that.
I realise that.
What? Right.
I realise entirely that's what you're saying, which is why I'm saying that we will have to have hearings between now and then fixed, so that you can tell the court exactly what is going on and with necessary evidence. I say I regard it very unsatisfactory that we're dealing with all this without evidence. And so when we come to deal with it in the future, we will have then evidence, and I'll be able to take a more informed view.
I understand. All I want to flag at this stage is that, if you like, the timetable is, as I said, fragile. So, I mean, you talk about latitude. This is coming directly from Young.
I understand all of that.
This is what our position is. it will understand it is the nature of the order that's being made, because obviously when we come back, you're going to get a lot of submission from my learned friends saying, well, you need a change of circumstances, you need this and you need that. And I think it would be helpful if your lordship was to give an indication that, you know, we're not in that territory, and that it's a question of coming back to you with proper evidence of what has happened and reliable evidence of what's going to happen next. And then you can form a view as to whether you're satisfied with all of that.
Well, I think the transcript's already recorded what I've said, so I think it's pretty clear. I've said I'm making this order on the basis that you're telling me it's unrealistic. But in order to establish that, you're going to have to come along later to show why it's unrealistic and what you've done, and that you've behaved with due diligence and all has been done that could possibly have been done to achieve the court's order.
That's very helpful, my lord. Thank you.
I don't know whether it makes sense to try and fix those dates right now for further hearings. There was discussion of a further hearing being needed in October in relation to search terms. Well, we'll look at dates and so on. But I'm not going to set any dates by which any specific matters have to be dealt with in the process of disclosure. We didn't do that before, I don't think, did we? We did, perhaps in relation to custodians, did we?
No, I don't think we did.
No, we didn't. No, we didn't, and we'll deal with custodians today.
Yes.
The only my lord, apologies to interrupt. The only issue there is between us is the process for agreeing search terms, my lord.
Yes.
Let's talk about the hearing or a paper determination. We're very much in your hands as to how we deal with that. But that was the disclosure process, I think, that the parties were suggesting we need directions for.
Yes. Well, I'm still hoping that you might reach agreement on that. But the only question then is, within the context of you being ordered to do something that you say is unrealistic, when is the best moment to discuss search terms and absence of agreement on them?
Well, I think on that, my lord, I think it would be better to clear away search terms as soon as possible. I mean, I had said an October date, but we would be happy to move much more quickly than that. It does need to be wrapped up, because then everyone knows where they stand and everyone can get on with their exercises, which is really, you know, so I don't, in terms of where one flexes the timetable, it seems to be one shouldn't be indulging the lawyers to debate on the niceties of search terms. They just need an agreed set, and if that can't be agreed, it just needs to be determined by the court swiftly. I don't think anyone relishes a hearing on search terms,
No.
and the courts often don't. And that message hopefully will be heard by the lawyers loud and clear. There is still opportunity for them to make a real effort to agree things, and really it's only if there are fundamental issues of principle where there are clear divergences of opinion that are properly justified that there should be any issue for the court. But I mean, for our part, my lord, it's entirely down to your diary. If you're available next week or the week after, we would be very happy to come back and have that as the milestone for search terms.
Just a couple of points from me, my lord. In terms of it's not just the search terms that are up in the air. It is also the timeframes for the searches themselves, which will determine the data to be extracted. So it's not just a question of search terms, because we're obviously, if an employee has been there for 25 years, we're not going to take all of their data just because they're a custodian. So that will also need to be done. Just so you understand the scale of the task, if you go to page 605 of the bundle, you'll see the response that came back last week. It starts a couple of pages before, but it's preamble and headings. And you will see the markup is the changes introduced by the claimants to the draft that was sent to them on the 1st of August, and we received it. Now, you just to, I'll just give you a sense of it. So if you go, for example, to Edward Carton, do you see there? The suggestion is that we're dealing with keywords that include job, role, if you go over the page to 606, transfer, terminat, which is intended to catch terminate and termination. So these are very broad. I mean, anybody who describes or any kind of job or role or any word of that nature will catch a document. So there are real issues to talk about here. There's a lot of further custodians, obviously, that have been added, so it may come down if you disagree with some of that. If you go down, for example, to page 649, you will see in relation to some of these custodians, we're looking at search terms like Dubai, Middle East. So really very broad. There's a little bit to be discussed about whether or not that really can be seriously, the search term that's input into this kind of data. I mean, one would have thought Dubai is going to bring in with it very many. We have asked.
Well, this is all, once you get into the sort of ands and the links between words, isn't it, that then comes into play. But
well, that's right. But at the moment, they're not.
The question still is, Mr. Montague-Smith, when is the right time to be grappling with this? As I say, very often the court is much less able to deal with these questions than the parties are, who have much more experience of how it works in practice and how using link words or not using link words impacts upon the results. You'll bear in mind that those of us of a certain age did not involve ourselves in the disclosure when we were at the bar. And
yeah, well, quite.
My Lord, I have
left the bar quite a long time ago.
Yeah, and so the idea is that the parties should try to agree these, and this is the sort of thing that one has to get out ahead of. But what we suggest can't be right is that the claimant sit on our suggestions for 6 weeks, present us with what is a huge amount of data, and then say you've got to respond by Friday, which is my learned friend's position. So we've asked for 10 days more till the 7th of October to give our response to these points, followed by a meeting, and then we're in your hands as to where we go from there. I mean, ultimately, if we can't agree, we can't agree, and we'll need to get your lordship engaged in this. We hope that can be avoided.
Yeah, well, what I was going to suggest, let me make a suggestion and see if that, if necessary, I'll set a timetable for parties to respond to one another and have a meeting. But I could, and it's almost the only dates I can offer you, I think. You could have the 25th of October would be a possibility. And then there may be some time available in November, subject to, yes, I could do something in the week of
Availability.
Yeah, also
do something in the week of the 11th of November, if need be. Those that I think are the realistically.
reason why the end of the year doesn't work.
I think Ms. Martin's point I've just heard is the fair one, which is that this needs to be swept away urgently so that they can get on with their exercise. Can I just make two observations? One is that our view is that the solicitors should meet as soon as possible to see what they can agree, because actually, this is classically stuff that they're very experienced in dealing with, and there must be a route through. And as your lordship says, it's about coming up with a combination that captures the sentiment without capturing the irrelevance. So, I mean, I think for our part, we would prefer the 25th of October, but that really should be a hard stop. I mean, the expectation should be on the parties that this should be agreed well before then. I mean, what I want to avoid is a world where my learned friends say we can't start our disclosure exercise because there are arguments over a few keyword searches. I mean, they've just got to get on with it. And actually, if they were sensible about it, there's a lot that they could do right from now. And the use of technology-assisted review is meant to help the process. And the idea that somehow you have to have a sort of complete set before you start is wrong in principle, and there isn't any evidence to support that. So I think we would just say that we suggest that the court orders the parties to meet mean, within the next 7 days, and then after that, if there are issues, then it can come back before the court on the 25th of October.
Well, I think that just a couple of points from my side, my lord. I'm afraid I'm travelling on the 25th, so either I don't have to be involved in this process, or I can't have a hearing. Then I don't know how we want to resource that.
I can offer you the 23rd or the 24th, subject to the fact I've got to give a lecture on each day at just gone midday.
I'm travelling in Kazakhstan that week, all week.
Right. Okay.
Commitments, I'm afraid, but I mean, it may be that others can do that. Or I mean, what we had suggested was that perhaps your lordship would just be able to deal with it on schedules, rather like a document process, and make a quick decision. I mean, we're very much in your hands.
I'd much rather not do that in writing, on the basis that I recognise that my understanding of these things is much more limited than in other areas, and therefore I would value, if I have to make the decision, parties being available to explain to me why they take the view they do about particular search terms. I just don't. I'm not happy really dealing with that sort of question on paper alone.
Very good. All right. Well,
so let me see what other dates I can offer if it helps.
My lord, can I just make one other observation, which I hope would be helpful? But in my experience on disputes and search terms, what the parties tend to do is actually apply it to their population of data to see what it's generating.
Yeah,
because sometimes
the number of hits.
If you're searching for Dubai and you get 50 documents, I mean, some of these are Swiss-based witnesses, which I think is the reason why the language is like that. If you get 50 documents, you're fine. If you get 50,000, then you have to just go and rethink. And that it tends to be an iterative process with discussion between the parties, coming up with a pool that is reasonable to review. So, I mean, that to some extent, as soon as my learned friend can get his data up and running and actually test these, then they can come back to us. And if they say, look, I've tried MVL and I'm getting a vast number of hits, then that's when you introduce keywords. And actually, my experience of the court having to make rulings on keywords is that in the regrettable position where the court is dragged in, it has to give the statistics of, well, the reason that this particular keyword is problematic is because it's generating a great number of hits. I'm not sure how your lordship could rule on that without that data being available.
Well, I mean, and then we're back to the position that your lordship has heard but needs to be convinced about, which is that we're not going to be in a position to run keywords on data by the 7th, 10th, whenever you want us to meet with the other side, or indeed come before you to talk about it. If we want a once and for all decision, we're just going to have it. And it's going to have to come. I mean, can I suggest that the parties then, we will need a little bit of time to go through all of this. We proposed the 7th of October to provide some responses to these searches. So what I would suggest is that we do that, and then the parties meet in that week. And then I think we'll need to take away, if your lordship was able to provide us with your dates of availability, we'll just have to find a date to pencil in as soon as possible for determination of that issue, following discussion between the parties as to who is available on those dates. I think it's going to be hard to schedule that at this notice, but there we are.
Yeah, well, there's a certain flexibility, as I now see in my schedule, because of a settlement that is in prospect and is likely to occur. But broadly speaking, once we get to the 7th of October, and then let's assume we have a meeting later in that week, I can do nothing until the week that you can't do, Mr. Montague-Smith. I have possibilities in the following week, the 28th, a likely period of days in the week thereafter, if this case settles, which I think it will. So I have possibilities in the week beginning the 28th and the 4th, 28th of October, which would actually be on the 28th itself or the 1st. And then some possibilities in the 4th, if this case, the week of the 4th, but if this case settles. So if you want to liaise with one another and see which of any of those dates work for you, I think it just makes sense to put in a date in the diary, even if it doesn't have to be used, so that we can iron out and see exactly where we've got to.
Yes, and of course, yes, understood. And of course, we will be 6 weeks down the line. That may be an opportunity to tell you.
Yeah. Right. Yes. You can make whatever submissions you need to make, Mr. Montague-Smith. I understand.
Provide you perhaps with evidence as well. Very good. All right.
So, shall we leave it that you'll liaise with one another and get back to us on which dates out of those lot make any sense for you, or do you want to try and commit now?
I would. I think there will be difficulties for me personally with all of those dates, but I will need to see what I can do at my end and then discuss with the clients how they want to approach that.
Is Mr. Conte around? Presumably he's going to get enmeshed in the detail of this, is he?
Mr. Conte is around, and he looks delighted to be volunteered for such.
Well, he'll have Miss Martin in the background.
Well, I'm sure, of course. No, I mean, I exactly, and they'll need. If you just may give us the opportunity to take those instructions.
All right, well, let's leave that. I will say then the 7th of October for responses, and a meeting during that week.
Can I just ask on that, my lord? That I'm told by those behind me that they're not available that week. I think because of another professional commitment. So maybe the week after, or the week before, but the week after probably seems sensible.
Yeah, all right. 7th of October responses, meeting in the week of the 14th.
I'm grateful, thank you.
All right, and a CMC on a date to be agreed between the parties, but within the framework of what I've suggested when I look as though I'm available. I'm reasonably confident, in fact, that something will become available in the week of the 4th. I know I need to set aside there's a deal done, which is going to involve some involvement on my part in either a hearing or papers or something, but I can adjust things during that week, I think.
I'm grateful. I think the week of the 4th would actually work well for us as well, but we can use about that.
Okay.
My lord, if I may, can I move the debate on to custodians? And I'm hoping.
Yes. Let me just see
see
if I've received any email from Lena. No. Nothing yet has arrived.
Oh, yes, of course. I'm so sorry.
No. So let's carry on until Lena or someone else tells me that they are starving and need to disappear to.
Yes, well, I think amongst others, the transcribe. It's very important to keep the transcriber fully resourced.
Yes, whoever it is can keep going.
Yes. So my lord, on the custodians, I think the best way to do it is to run through them. We can run through them by category as to who they are. A lot of this actually does turn on who the people were and what their function was.
Yes.
So, but what I'm going to hopefully do is illuminate some general points about the approach we say the court should take on custodians, and then we will dive into some of those specific categories. And some of these illuminating points we've illuminated before, so I won't waste time spending much time on them. But there were 6 introductory points I wanted to make. The first, your lordship has made, and we've made many times. Of course, the nature of this case is a fraud case. By definition, it was a covert fraud. We don't know everyone who was involved, and it is entirely normal for the claimant to be in the dark as to some matters as to how the fraud was affected. And it's important that the disclosure regime in the DIFC works in fraud cases, and that it doesn't allow fraudulent defendants to cover up their wrongdoing. And so we say that for those reasons, one might be minded to take a slightly more expansive approach to the choice of custodians than one might do in a more vanilla, perhaps a breach of contract case. The second point is that we're largely looking at emails and documents from a decade ago. And although we live in a very data-hungry universe now, more than a decade ago, that wasn't the world. There weren't vast numbers of emails, vast amounts of electronic documents. And so one, again, might be less concerned about adding custodians because there's no evidence at the moment to suggest that adding any particular custodian would yield a very significant amount of data. The third point to make is that it's important to pick up all relevant custodians, not just a selection. And that's emphasised by the fact that it appears remarkably that some key custodians have virtually no documents. So take, for example, Mr. Sassoon. We look at the defendant's evidence about Mr. Sassoon's data. You can pick this up in Mr. Tourette's witness statement at page 492. And this is a statement that Your Lordship ordered following the concerns about the destruction of documents at the last hearing. Mr. Tourette gave his statement explaining the inquiries he had made. At paragraph 39, he sets out his inquiries about Mr. Sassoon's network documents. I've also asked Mr. Sassoon to show me his desktop, including the H drive, to ascertain from initial review what information may be stored there. Mr. Sassoon has almost nothing saved on his H drive from initial review. No folders were named in a manner that appears related to the matters in dispute. And then he goes on to talk about hard copy documents, paragraph 43, page 493. I inquired similarly with Mr. Sassoon, this is about hard copy documents, who noted that he does not store any documents in the archive. I visited Mr. Astruc's office to ascertain whether he has any, and then he explains about Mr. Astruc. And then he goes on at 46 to say, I've also visited Mr. Sassoon's office to ascertain whether he has any potentially relevant documents. Mr. Sassoon's desk is kept clean and there are no large storage cabinets in his office. It contains a desk with 2 screens, a second table for meetings and some decoration. He has a couple of small drawers in his desk which do not contain any potential relevant documentation. Walking around the BJSS office space in Geneva, there are no large file cabinets and most of the custodians have a paper-free desk. So someone like Mr. Sassoon obviously had a very senior position within the institution, as one of the key people that we say is an architect of this misconduct. And what we're being told is no electronic documents on the network for him, and no hard copy documents in the office for him. And this is a gentleman who, since 2013, has been employed as the head of private banking region 2. And obviously that covers this particular region. So one slightly wonders how you can be a head of division and run a business like this without any documents at all. But anyway, in relation to Mr. Sassoon, we're being told that we can't expect much of anything to be found in his disclosure. And again, we say that this illuminates the question of whether you should look elsewhere. And that brings us on to my fourth point. I've picked this up briefly before. There's no evidence for the defendants about any cost of adding a particular custodian. Their reasons for not commencing the disclosure process were based on concerns about fixed costs, not variable costs. And there's nothing to suggest that the variable cost in terms of uploading particular custodians is material. The cost will obviously come if there's lots of relevant documents identified as part of the custodian's data. But in those circumstances, I mean, that's the entire purpose of this exercise, is to find relevant material. So if cost is driven by a custodian yielding relevant material, then that is obviously a good reason to include them in the first place. The fifth point is the defendants have made it clear that this needs to be a single exercise. We don't fully accept that. We say that it's often the case in commercial cases like this that the exercise is iterative, but we do recognise that because of essentially the constrained timetable, because of the letters of request process, it's likely that we won't get documents until quite late in the day. I mean, we're talking about getting the non-letters rogatory documents in the new year, and the letters rogatory documents, we just don't know. So that does mean that realistically, there are not going to be multiple times to go back and add in additional custodians, because the horse rather would have bolted. So again, we say that's a reason to be a bit more inclusive at this stage. So, my lord, with that introduction, perhaps I can just move on now and talk about the disclosure by categories. And I want to start with BSA, so my client's directors, and they are Mr. Sarasin, Mr. Gertz, Mr. Wiels, and the company secretary, Mr. Rajiv Phillips. Now,
hey, could you just repeat those?
Of course. So this is Mr. Sarasin, Mr. Gertz, and Mr.
Which Mr. Sarasin?
Eric. This is Eric Sarasin.
Yeah. Gertz. Yeah.
Mr. Gertz and Mr. Wiels. Peter.
Yes.
Yeah, Peter Wiels. So those three, and then there's also the company secretary and compliance officer, who was called Rajiv Phillip. And your lordship might remember some of those names, but certainly Mr. Phillips' name is, he was intimately involved in the scheme, and there's extensive misconduct alleged against him in the particulars. We'll come back to him. So I've got some 5 sort of general points to make about this category, and then we'll look at the individuals more specifically. The first is that for the 3 directors, they were directors of my client, Bank Sarasin-Alpen, and they worked for the 4th defendant, and their data was, as we understand it, hosted by the 4th defendant. The second point is that some of that data held by the 4th defendant will simply be documents created by these directors in carrying out their role for us, qua director. That leads me to the third point. As a matter of the law of agency, a principal, i.e. my client, is entitled to call for his agent's documents in relation to the carrying out of his duty as agent. So as a matter of general principle, we ought to be entitled to see our agent's documents in the discharge of their functions. And then the fourth point on top of that is that my other client, the liquidator, actually has a statutory entitlement under Article 53 of the Insolvency Law to inspect the books and records of the company, to direct the officers of the company to produce their books and records, and to give information. And your lordship will be very familiar with those, and it's a similar regime in England. My fifth point is that these directors owed a fiduciary duty to my client to act bona fide in its best interests. And if they came across any information that was useful to my client, they were obliged to pass it on. And if they acted in breach of their fiduciary duty in any way, they were obliged to tell my client. Now, the defendant's own case is that the defendant's own case is the 4th defendant wanted to leave the joint venture. And those individuals who were directors of my client, Bank Sarasin-Alpen, and senior officials of the 4th defendant would have obviously been involved in those discussions. And we know, and we'll look at this in a moment, from the defendant's defence, that essentially one of the cornerstones of their defence is that there was no scheme in 2013, because actually in 2012, they had been looking for strategic reasons to divest themselves of this business. And they say that they were looking to do that in 2012 because the 4th defendant had a new owner. There was a change in culture, change in corporate direction. There were concerns about the credit policy that had been applied and the credit demands of Bank Sarasin-Alpen. And all of those factors led into this strategic decision in 2012 to divest themselves of the business. And so we say, just sort of pausing.
Their original intention, as I understood it, as pleaded, was not to divest themselves of the business, but what they didn't want to do was to go ahead giving people the leverage that they had previously had. They didn't want to lend so much for people to make investments, and that was the basic policy difference between the 2 partners of the joint venture. Have I got that right?
Well, I mean, maybe I'll take you to the pleading actually, just to see how they've put it. I think I suppose the main point that I want to emphasise at the moment is that the defence is that there was a strategic misalignment in 2012, and identified that the two joint ventures were a poor cultural match, and one can see that 161 paragraph 7, so actually 6 and 7 of their defence, second sentence of 6, BSA's two corporate parents are no longer aligned, misalignment apparent to BSC and its new corporate shareholder a year before the claimants alleged defendants to have hatched the ostensible fraudulent scheme. This timing is evident from BSC and JSSH having retained Herbert Smith to advise them in October and December respectively. And then it goes on really to explain that on the defendant's side, certainly on the fourth defendant's side and its parent side, there was a strategic view that this was an unsatisfactory joint venture, and that strategic view then helped explain their conduct in 2013 and beyond. So on their own defence, that 2012 period is a key point. And we don't need to spend a great deal of time looking at it, but at paragraph 45.2 of the defence, they deal with this misalignment on the credit policies, and that's really sort of paragraph 45 of the defence at 172 and 173. I mean, we talked to your lordship about that in the past. And if one goes to then 46 at page 174, there was a decision. So paragraph 46, paragraph 21 is omitted, say that the decision by BGS's management to pursue the option to incorporate a wholly owned DFSA license entry was undertaken in 2012. So again, strategic decision to have their own entity incorporated in 2012.
No more precise date than 2012 given.
No, but if you look at the next sentence, it tells us, without waiving legal privilege, GSSH received legal advice in respect to the incorporation of a wholly owned subsidiary from October 2012 onwards. So one would assume that the strategic decision was made earlier in the year to allow time for someone then to find lawyers, instruct them, and for the lawyers to produce some advice. But there isn't an illumination as to when exactly in 2012 that was. Sorry, if we just go forward to 182, paragraph 65. Second sentence, there explains that following these sort of strategic considerations, there were meetings between the representatives of Alpen and the fourth defendants to discuss the future of BSA's operations, and they took place since at least November 2012. So we can sort of see that the policy, the strategic directions already started to play out by October, November 2012. Now, the directors that I have identified are both senior officials of the fourth defendant, and they were also directors of Bank Sarasin-Alpen. And we say it's obvious from the defence that's been articulated that they must have been heavily involved in these strategic discussions, including considering the relationship with Alpen, whether the joint venture was working, whether they wanted a new entity, whether they wanted some way of exiting the company that they were in. And that case is central to the defendant's defence. They don't accept there's a scheme. They say that the conduct in 2013 was explained by 2012. And so obviously we need disclosure of what the directors were doing in 2012. Now, if you look at the way that my learned friend deals with this in his skeleton, this is at page 288 of his skeleton. There's a table, and he sets out there the relevant custodian. He identifies their role, and then he goes on to give his reasons why he doesn't agree for their inclusion. So if we start with Mr. Sarasin, Eric Sarasin at line 5. He lists out the role. Now that's incomplete. I'll come back to that in a minute. But just look at his reasoning under the final column. He says this is a legacy Sarasin appointee, and he's not relevant, has left BSA's board at early stage prior to C's pleaded scheme. Any potentially relevant documents are likely in the possession of already agreed custodians. Now, if we look back at Mr. Sarasin's role, So he was on the BSA board till the end of 2012. He was also a director he's also on BGSS's executive committee for a long period from 2004 to 2014. My learned friend doesn't mention his other roles. So Mr. Sarasin was co-head of private banking. He was also on the credit committee, and he was also the deputy CEO. That's not mentioned. If we pick up Mr. Gertz, because Mr. Gertz is basically in a sort of similar territory. So Mr. Gertz also had similar roles to Mr. Sarasin.
Well, I mean, I've read all this, Mr. Shipchi. It's in your appendix.
Yes. Okay. Fine. Well, I can take this very swiftly. Just a couple of points to illuminate. One is that the dates for Mr. Sarasin and Mr. Gertz holding their relevant offices are not the same. There's not actually a complete, if you wanted drawing a Venn diagram, there wouldn't be a complete overlap of their positions. They had similar roles, but they weren't overlapping. Mr. Sarasin was on the credit committee longer. Mr. Gertz was at BSA longer. So their universal documents would be slightly different. Their role in the credit committee is important because of the defence on the change in credit policy. And the defence haven't identified anyone else apart from Mr. Gertz and Mr. Sarasin who would actually have the documents that they would have from those functions within the organisation. So that's sort of the first major error in my learned friends approach. The second major error is that they assume that if someone left before the scheme, then they're not relevant to this case. And I've demonstrated to you by reference to their pleading that point is wrong. So that deals with Mr. Gertz and Mr. Sarasin. There are directors. We're entitled to their documents. They're plainly relevant to the chronology. Now, Mr. Gertz and Mr. Sarasin were the private banking heads. Mr. Wild was the head of trading and family offices, and his role was different. But because some of the client relationships which were diverted would have been family office type relationships, his views and position would have been very relevant as well. So one can easily envisage a world where in 2012, D4 was looking at this business and looking at all these issues. It would have been consulting the heads of private banking, and it would also be consulting the head of family. And there is no reason to think that the heads of private banking would have the same documents as the head of family. Now,
is there any evidence about what the executive committee does?
We have the delegation of responsibilities. My junior will just send me the reference for that, and I will show you that. So there is a document which sets out the sort of the governance responsibilities. I have shown you that before.
Yeah, I've forgotten it, I'm afraid.
But it's, I mean, as someone who's a specialist in governance, I sometimes feel these governance rule documents are not very illuminating in that they tell you, in a sort of essentially terms of reference, they give you a broad idea of what a committee or board is intended to do, but actually where they spend their time is a quite different matter. But I think just on that, though, I think it's really important to remember that my learned friend points just to these committees and the boards and says, oh, well, you'll have the board disclosure and that will be enough. But that confuses the role of a committee member or a board member with the role of an executive. I mean, these people were running their departments and they would have had frontline teams, day-to-day activities and discussions outside board meetings, probably factual investigations outside board meetings. So it is not realistic in the running of an organisation to say, oh, well, everything material would have simply been in a board minute. I mean, and actually sometimes organisations are a bit reticent to put their innermost thinking in detail into a board minute. So I just want to make that point insofar as it's suggested that because other executive committee members are in disclosure that we'll get it all.
Yeah, well, I'm much more troubled by Mr. Wild. It seems to me his focus is head of trading and family offices division.
Yes.
And yes, it's true that some of the clientele may have been in that business of family offices and so on and so forth. But
yes,
I don't see him as being in the same category as the first two, really.
But well, obviously the nature of the role is different, but on the other hand, these are the family. I mean, as I know from my own practice, the family office relationships are incredibly lucrative because they are, that's sort of where the billionaires sit. So I agree. I agree that this is a case that focuses quite heavily on private banking, but if you're a bank looking for the most lucrative relationships, you're gonna hunt down the family office ones. And let's just pick up a document on that. If at 3165, if you go to the bottom, so this is
not there yet.
So sorry.
Yeah.
So this bottom email coincides with that decision to instruct Herbert Smith Freehills and this review of the strategic relationships in October 2012. And there's an email from Joe to Mr. Gertz, Mr. Sarasin, and Mr. Wield, and the subject is Visit of the 100 Most Important Clients by Jacob or Joseph Safra. And the emails, dear colleagues, we should organise visits to the approximately 100 most important clients of Bank Sarasin, together with Jacob or Joseph Safra. Please prepare a list of your 30 to 40 clients which you feel would be important to meet. In our next DU meeting, I think this must be Dubai, we can then discuss the time schedule. Please let me know if you have any questions. Kind regards, Joe. And then if you look up a level, Mr. Gertz forwards that on to, amongst others, Mr. Walia. And then there's an email exchange involving Mr. Walia about this. Now, what that email at the bottom is sent to the 3 directors of my client, and Mr. Wield is obviously one of those. And we say the reason that Mr. Wield is included is because they're interested in the family office relations. And you would expect that the 30 to 40 clients, and this must be clients of BSA, 30 to 40 clients would include some family office clients, because if you're doing it on net worth, they would be up there. And Mr. Wield's consideration of those sorts of clients is not going to necessarily link in with the private banking people. It will be a different client base with different client relations. So we would say, my lord, that you should include Mr. Wield. To bring you back to my points about the directors, he was one of our directors. We are entitled to call for his documents. And for example, this sort of exercise, he couldn't legitimately say no to us because he was our fiduciary.
And what of that? That still the question arises whether he's got anything with him. But yeah, well, more material.
Yes, but
you may be entitled to see it. Of course, I understand that. But
yeah,
you're not making a claim against him for delivery up of his documents. You're making a claim for disclosure.
Yes. No, exactly.
Anyway, there we are. I've got the point.
You've got the point. And just on the family office side, we know that certain clients were in the family office. So, for example, at 3090, this is an email about Jafar, a client called Jafar. And if you look, this penultimate paragraph, it talks about meetings with Mr. Jafar's head of family office in Liechtenstein. And at 392, there's an objective. 3092, objective of this proposal. Bank Sarasin has a relationship since 2010 with Crescent Protagonists Corporation, majority owned by the Jafar family. Talks about the revenues being generated. Relationship very strong. Objective is to attract the family wealth and also do more PB business with a new entity established to manage the investments of Crescent Enterprises. So,
where are you reading from?
Sorry, that was at 3092 under objective of this proposal. Does your lordship have that?
Yes. Yeah,
And
I'm not quite sure why you're showing me this, but there we are.
Because it shows that the bank is targeting the family relations. And I won't give you all the references, my lord, but there's another one at 3168. That's in relation to the Canoria family. And so all I'm saying is that there are the family office business is material, as well as the private banking. And ultimately, we'd say that in the grand scheme of things, the level of disruption of including a custodian like this will be minimal, but this is realistically one's best chance of actually capturing his documents. And if there are no responsive documents when search terms are applied, then so be it. Can I just move on, my lord, just to deal with Mr. Weinberg,
Yes.
who is D4 nominated director of my client from October 2015 until the company's liquidation. That was obviously later, but that period is relevant in terms of the defendant's intention to defraud creditors. On Mr. Weinberg's appointment in October 2015, it would have been immediately apparent to him that the company's business had gone elsewhere, and he, in all likelihood, would have realised that it had gone to D5. He would have learned that through his position for the fourth defendant. We'll need to understand why he took no action. Again, during this period, it's highly likely that he would have been aware of the inquiries from the DFSA about the winding up of my client's business. What did he say in those internal discussions about that? What did he know? Now, we also discovered that in the course of Mr. Hayder's inquiries, he found that a particular folder on my client's systems named Finance had been deleted from the service of the company, and he wrote to Mr. Weinberg and others to ask about that, and the responses were provided by Norton Rose. But again, Mr. Weinberg may well have material personal to him, which explains why items were deleted. What appear to be very critical documents were deleted. So, and just going to my learned friend's explanation as to why Mr. Weinberg should be excluded, they say at 2767 at the bottom, they say they do not include his inclusion whilst he was a member of BSA's board from October 2015 until its compulsory winding up in 2016. He was not a board member during the planning or execution of the alleged scheme. To the extent that Mr. Weinberg may be in possession of documents related to any intent, these documents are likely to be in the possession of BSA's other directors, including Mr. Astrict, who is an agreed custodian. Therefore, highly unlikely that Mr. Weinberg will own any documents not already in the possession of agreed custodians. But we say that the logic of that just doesn't follow, given the point at which he was appointed, what was going on at the time in the inquiries that would have likely been put to him. And in any event, if you look at the other directors, one can't be confident that they will have a complete, comprehensive set of records.
Sorry to interrupt, my lord. We're having a timer, a countdown has appeared on the screen here, telling us that we're about to power down. Oh no, we've solved it. Phew. Just on the 007. I apologise for interrupting. Please carry on.
No, not at all. So, my lord, maybe I could move on to Mr. Rajiv Philip. He was my client's company secretary and compliance officer. He is included as serious misconduct and involvement in the scheme, and then, like many others who worked at my client, he then moved to the fifth defendant. My learned friend Skeleton says he started there in March 2014. We don't think that he's right about that. We've actually alleged in our plea that he started in March 15. That's something the defendants have denied, but they haven't actually pleaded as a start date. But we think we're right. We suspect my learned friend's made a mistake in his Skeleton. Now, Mr. Philip is a custodian of our client, so we have agreed to include him as a custodian, and we have agreed to search his data through to May 2016. However, the defendants refused to have him as a custodian, notwithstanding his role in the scheme. Now, Mr. Philip went on to be the fifth defendant's compliance officer, and he dealt with the DFSA, and that's in Mr. Swan's statement at page 483. He was also involved in the 2015 audit report. I don't know if your lordship remembers this audit report. We have looked at it before, but there was a lot of material. Can I just show you this again? So this is at 2522. And this was an internal audit by the fourth defendant of the fifth defendant's client onboarding processes. And this, if you can see at the bottom of 2522, fieldwork started for this in February 2015. It ended quite shortly thereafter, later that month. And then there was a report issued about 4 months later. And in that intervening period, Mr. Philip came on board, as we understand it, for the fifth defendant, and then the audit conclusions were provided to him, and he signed off, essentially understanding, acknowledging the conclusions and the observations and committing to the recommendations. And that's at 2526. Does your lordship have that?
Yeah.
Now, this audit came about because the DFSA had conducted a first risk assessment of the fifth defendant, which resulted in a report in January 2015, and essentially raised some material concerns about client onboarding processes, with an implementation deadline of the end of April 2015. So when Mr. Philip came on as compliance officer, he would have been dropped straight into this. The FSA had essentially recommended action on client onboarding. Time was running till April 2015 to carry out the remedial action. There was then an internal audit, and the audit, in fact, came up essentially with sort of various concerns and recommendations. And out of a mark of A to D, the performance was marked as C, and one can see that at the top right-hand corner at 2522. Now, the audit itself concerned, I mean, what I think is something very important for this litigation. It looked at all of the clients onboarded from the 1st of April 2014 to the 31st of December 2014. If you can see that at the middle of 2523.
Yeah.
So it looked at the onboarding of clients, many clients who were relevant to this litigation. That was a crucial period in terms of onboarding clients for D5. And as the second paragraph of that page says, in that 8 months, the fifth defendant had engaged some 40 staff and onboarded 330 clients, of which 125 were new to the group. And we previously made the point that implies that the remainder were not, and implies the remainder were actually previously clients of my client. But this, the point I'm trying to make good at the moment is that this audit was of the onboarding of clients that we say were taken from my clients. Mr. Philip would have had to have intimate understanding of those processes, because there were complaints about that process by the DFSA, and then the process was examined by his own internal audit, and then they made recommendations. And Mr. Philip would have also seen not only the onboarding of those clients at D5, but he would have seen the offboarding of them at my client, because he stayed at my client until March 2015, essentially to oversee the departures of those clients. So we say that he's plainly a highly relevant person whose job when he started at the fifth defendant was looking at one of the central questions in this litigation. And it would have been crystal clear to him through that investigation exactly how clients were onboarded, what was said to them, what carrots, etc., sweetness given in order to persuade them to come across. Now, if we look at my learned friend's skeleton argument, his explanation for excluding Mr. Philip, this is at 2893 of the bundle. He deals with it at the bottom of the page. And he says simply, the C's request the inclusion of Mr. Rajib Philip. Mr. Philip joined the fifth defendant on the 2nd of March 2014. I think he's wrong about that. He says this was more than 5 months after BSA terminated its client relationships. Any relevant documentation pertaining to clients following the termination will be within C's possession during the time when Mr. Philip was an employee of BSA. Well, I mean, that just really looks at only one side of the coin. So he says that because we've got the BSA side of things, that's good enough. But he's obviously wrong about that, because what matters is actually what the clients were being told from the D5 side of things. And Mr. Philip will have an intimate understanding of that. Now, there were some other people who were also involved in that audit process. And one can't at the moment know whether someone like Mr. Phillips' records are intact or whether they are not there for whatever reason. So we say for that reason, it's sensible to include the others who were involved in that process. We've proposed Christina Myrene, and she was the lead auditor for the audit. And again, you know, she would have had to conduct a proper review, and one would expect. And my learned friend's answer in relation to her is at 2889. If you look in the final sentence, they say relevancy denied of the audit function for the current case. And we think that's an unreal submission. To say that that audit was irrelevant in relation to this case. I'm afraid to say that this point sort of rather highlights the defendant's approach to the selection of custodians. You know, we're not talking about peripheral individuals where one can't understand why the claimants have asked for this. These are obviously key people who were involved in examining the conduct which forms the underlying basis of this case. And I mean, one can see why the bank's keen to keep these custodians out, but that's not the proper way to litigate. Now, can I also mention two other individuals who are also involved in the audit? That's Mr. Dupont. And if we go back to 2522,
yeah,
he was a member of the audit committee. He received this, and also Mr. Hayem as well. And we've asked for him to be a custodian as well. Now, we just don't have visibility of what inquiries the audit committee made in relation to this. One can see that where the regulator had investigated wasn't happy and come up with recommendations and a deadline, that might have involved some direct engagement by members of the audit committee. There might have been correspondence, etc. One can't know. One can't be sure that everything was simply covered in the audit committee meeting minutes. But anyway, that explains why we've added those two. I wonder next I could pick up Mr. Dr. Philippe Mayer. Now, he was a member of the Fourth Defendant's legal department and involved in key events and correspondence. He was the person who engaged Herbert Smith Freehills in 2012. And that engagement, that retainer letter and the engagement was in relation to Bank Sarasin's joint ventures with Alpen Group and any related litigation or arbitration proceedings. So, I mean, it was a broad compass that would have picked up all the things that are relevant to this case in terms of both the Carafi litigation, the relationship with Mr. Walia, and obviously the strategic desire to try and exit the joint venture. On top of that, he had other involvements as well. He was the person who was responsible for setting up the fifth defendant. Little question, and that's at 2671 of the bundle. The question is, well, why, for what purpose, what was he told? I think that we get a rather glib answer from the defendants, which is that the purpose would be evident from the formal incorporation documents. But that's like saying that reading a company's memorandum of association will give you an insight as to what the day-to-day activities of the company are. That's just an unreal lawyer's point. What we want to know is actually what he was told on the ground about what this business was going to be doing, and then the extent to which they decided to or not to share that information with the DFSA. Now, on top of that, he was signatory and presumed author of the letter at paragraph 21 of the particulars of claim. That also relates to the setting up of the fifth defendant. And he was also involved in correspondence with the DFSA. And that correspondence in 2013, the fourth defendant said its intention was for the fifth defendant to provide services to institutional investors. But that seems quite difficult to square with what we're now told was the 2012 strategic aim of finding a way for the unaligned shareholders to part company. So the communications with the DFSA about the nature of the business and the wider relationships with the Alpen Group are all relevant matters that Mr. Mayer would have been briefed on and would have then been instructed to correspond with the DFSA on. And just to pick up on, I said that glib point that my own friends have raised, that's at 288 in their skeleton. And they say in relation to Mr. Mayer.
Mr. Shiptier, I have been through all the appendices of on your skeleton and Mr. Montague Smith's, so that, you know, unless there are particular points that you aren't in there, I don't really need you to address me on them. And likewise from Mr. Montague Smith, I'm only interested really in any further points that are outside the scope of those skeletons that either of you wish to make.
Very good. Well, my Lord, I'll take the nudge on that. And can I just make there are just a few other points I just wanted to flag. First of all, for the in relation to the fifth defendant's directors, we say the court's approach should be illuminated by what's happened in terms of the destruction of documents. Now, the impression that the court previously has been given is that there had been no systematic destruction of the fifth defendant's data, and that is emails and non-client data. And that was said so expressly in Jones Day's letter, which is at 2659, and that was the letter of the 9th of June, the day before the June hearing. I'd just like you to have a look at that. That's 2659. Yep. And they say there, A, in relation to emails and non-client related data, neither the fourth or fifth defendants systematically purge documents on their network drives. The data from Outlook and Lotus Notes is stored in archives which cannot be altered by individual custodians. Our clients are aware of no data corruption issues. As such, the data in respect of these categories is believed to be intact. It's a very clear statement that there's no routine data destruction in relation to those they're believed to be intact. That was also what your lordship was told at the hearing the following day, and this is at 2168. This is some submissions from my learned friend Miss Martin, and this was in response to my complaint that there had been no document holds sent out. And she says there, a lot of this discussion is focused on notifications, and notifications are nice. They do let people know that they need to preserve things, but the measures that the fourth and fifth defendant have put in place are not simply a memo saying, please preserve. These are preventions from deletion. They are a technical note in the system that makes it so that this information cannot be deleted. We should say that this is far more robust than simply sending out an email or a formal memorandum, and hopefully the court will agree that it's certainly adequate in the circumstances. So that was the submission. Then we got Mr. Swan. Your lordship ordered Mr. Swan's affidavit. And I'll just summarise that to speed things up. This is paragraphs 34 and 35 of his evidence at page 477. But the essence of his evidence was focusing only on there being systematic purges of client-related data. So it's very clear in his evidence that the only systematic purges were client-related data. But if one actually then goes to the documents that show what was happening in the fifth defendant, there was a purge, what appears to have been a purge of documents from 2014 and 2015, and that was on the 28th of January 2022. And the purge seems to have been very broad and seems to have covered the documents that we were previously told had not been purged, were not being purged.
Page
922. So this document sets out, it says at the top 2014 and 2015 data purge confirmation. And then under company secretary explains what the purge is, board presentations, minutes of board meetings, AGM minutes, GI audit reports. And then if you sort of go further to the right hand column, it says under the column purge yes or not applicable, it says yes. And then also email correspondence, implying that the email correspondence in relation to them is also deleted. And then if you go on under business correspondence, documents on legal disputes, general legal topics, again, yes, with email correspondence, correspondence to the regulator DISC, again, deleted, purge if no longer relevant. And then if you go on through financial statements, financial reporting, risk reporting, lots of categories of document that seem to be deleted. But I'm focusing in particular on the sorts of documents that the senior management would get, in particular the board related material. We know that we are asking for the fifth defendant's directors to be included as custodians, and we're doing so in circumstances where we know that the sort of archives would have been deleted because of this purge. And this document, this purge authorization, is actually signed by Mr. Swan, who's witnessed him when I showed you, and that's in the top right hand corner. And as we understand it, this purge was effected, notwithstanding the contents of Mr. Swan's statement. So there was a purge, and that makes it all the more reason why one needs to pick out individual directors and ask them for the documents in their possession. And it may be that some of their documents have been deleted, which is why we've identified all of the directors, and there's three of them: Mr. Graff, Mr. Poser, and Mr. Saban. So, my lord, just moving on, I think the final topic that I wanted to pick up on was Mr. Zerman, Marcelo Zerman. We say that the defendants really have been keen to downplay Mr. Zerman's role in this. But we say that Mr. Zerman will have been, we think, involved in detail in the events underpinning this litigation. He was the chief operating officer of the Safra Saracen Group and appears to have been directly responsible for the client relationship managers at the fifth defendant, including in the handling of the Carafi litigation. We set out in our skeleton argument at 52 to 55 various points about his role, but he was, the press describes him as a member of Stafford Sarasin's top management, along with Mr. Sassoon and Mr. Astruct. As I said, he was COO throughout the relevant period. He would have, as the chief operating officer, he obviously would have been intimately involved in the setting up of a new operation, the hiring of new staff. It would have been his responsibility in that capacity to oversee the successful onboarding of staff and the operation, and to make sure the business ran to budget. We've identified in our skeleton the numerous times over the years that he was involved. He was involved in discussions between D4 and Alpen in 2012 in relation to the joint venture. That's 3080. He was involved in 2013 in discussions about how legal fees in the CRAFI proceedings were to be attributed between my client and the fourth defendant. That's 3084. He was the person who authorised Mr. Sassoon to negotiate with Alpen. He could have only done that if he had been properly briefed on what the parameters were and what was being negotiated and what the objective was. He would have had to consider the circumstances of my client's business, the opportunities in the region, and how the fourth defendant would take advantage of them. He's highly likely to have been comprehensively briefed on those matters to underpin that decision. It's striking that once the fifth defendant was actually underway, Mr. Zerman was then appointed as a director of the fifth defendant in May 2015. And that, we say again, is further endorsement of the fact that he likely already had an intimate understanding of the business from his operational responsibilities. He had other functions within the fourth defendant. We've explained that in our evidence. I think the last thing just to look at, actually, just to give a bit of a flavour of the sorts of things that he was doing, is at 3171. This is at the bottom of the page, an email from Mr. Phillip to Patrick Greeby, who is again impugned in this litigation, and he's one of the legal officers of the fourth defendant. Now, at this point, Mr. Phillip was the compliance officer for my clients, and the fifth defendant had already been set up, and clients had already, we say, been taken and moved across. And at the point that the CARAFI judgment was released, Mr. Phillip emailed Mr. Greeby and said, "Is there any official communication from the bank for the clients or regulators formulated in response to the AK judgment? I'm getting inquiries from remaining CRMs on this matter." Now, the remaining CRMs must be a reference to my client's remaining client relationship managers, i.e. those who have not yet moved to the fifth defendant. And he's asking, Mr. Phillip is asking the fourth defendant for guidance on what to tell those relationship managers who haven't moved. And Mr. Greeby responds saying, "No public official communication, but if you need guidance for the CRMs, please contact Marcelo Sermon, who has been handling this." Now, that shows Mr. Sermon's involvement in this, but if one then goes up again, sorry, to just pick up the point about him handling this, that we say that must be a reference to him handling it at the fifth defendant, because that's the sort of logical assumption of what Mr. Sermon is handling. He's handling what the fifth defendant CRMs who come from my client are telling clients, and that same message is going to be then rolled out to my client CRMs. And then if you look at the top again, Mr. Rajiv emails Mr. Zerman, and he says, "As advised by Patrick below, would you be able to share any specific communication that a CRO is allowed to relay in response to a client's request on BGSS's Bank Sarasin-Alpen's position following the handing out of the AK case judgment, taking also into consideration the distinction between the two entities?" And then Mr. Zerman responds to the top, "We can discuss it by phone. I'm available," and gives his number. So the distinction between the two entities is being drawn to Mr. Zerman's attention, and he is still advising Mr. Phillip on what my client's relationship managers are going to tell their clients. Anyway, that's just sort of one snapshot of Mr. Zerman's involvement, but we say that he is a key character, and it really would be unsatisfactory for the defendants to avoid his documents being scrutinised. Now, my lord, you have our submissions on the other custodians. Can I just say something about Herbert Smith's Freehills? One doesn't need to get awfully stuck about the identity of the custodians. Our point is.
Sorry to interrupt, Mr. Shivji. So sorry. We had a message about, I think, 15 minutes ago from the transcriber asking for a break. I think we're approaching the 2-hour mark now. I don't know how you want to deal with that.
And in fact, I'm so grateful to my learned friend for identifying that. I'm terribly sorry I missed that. I'm very nearly finished, but I'm very happy to pause there for a break, and I'll wrap it up when we come back, if that's convenient to your lordship.
Yes, all right. So if the transcribers are needing a break, let's take a 10-minute break now, and then you can finish off.
Very good.
All right. 5 past the hour, please.
Thank you.
Yeah, when you're ready, Mr. Shivji.
I'm grateful, my lord. So my lord, I just finished up Mr. Zerman. There was just one other category that I just wanted to draw to your attention, which is alongside the specific custodians, there are certain areas where we have asked for further information to identify relevant custodians. That's covered in section C2 of my skeleton at paragraphs 64 to 70. And I mean, this is classically the sort of thing where cooperation between the parties ought to yield a sensible set of custodians to capture the relevant documents. And we've asked repeatedly for this in our letters of June and twice in September, and our requests have gone unanswered on this. We've explained what those categories are. I mean, all we want is a bit of guidance as to who appropriate custodians would be to capture these documents that we're after. The categories themselves are plainly relevant, and we've covered that off in our draft order, which is at page 3062, and that's paragraph 3 of our draft order. But unless your lordship wants me to, I don't intend to repeat what I've said in my skeleton there about the categories we want and why we want engagement on custodians.
With your permission, my lord.
Yeah. Yes. Thank you.
All right.
I'm more interested, Mr. Montague Smith, in let's say points that aren't made already, rather than points that have been made already in the documents. So if you want to say anything specifically about categories that hasn't been mentioned, categories of people or what have you, that would assist.
Yes, I'll try. What I was going to do is just run through, just to summarise as well, but as quickly as I can, and I won't take as long as my learned friend. But one of the points that I was going to make was that quite a lot of the points you'll see in the skeleton arguments, quite a lot of the points my learned friend raised today are raised for the first time. And so some of the allegations actually, in particular in relation to missing folders, have been resolved. So my learned friend's client has came to us and said, we've now found the missing folder. So there's sort of a suggestion to you that somehow a document or a folder had been deleted and was missing, but that is not the case. The former liquidator confirmed that has been found. There are other points about data purges. So, for example, you were taken to the document at page 922, which identifies a list, and my learned friend characterises that as evidence that there has in fact been a purge of certain emails. My instructions are that is not what has happened. And that was a policy document, and there has been no purge of emails in accordance with those. But those are instructions I'm taking on the hoof, because this particular discrete issue that is being raised has never been raised before my learned friend's submissions to you today. So what we have been trying to do was identify the scope of the dispute about all of this. The other point that's made is Mr. Sassoon. It suggested that he won't have any emails. Sorry, won't have any documents to disclose. That was one of the first points my learned friend made to you. You were taken to a witness statement at page 496, and you will no doubt have observed that the section of the witness statement he took you to was dealing with electronic repositories of documents. And so Mr. Sassoon will have, obviously, lots and lots and lots of emails, and it is really emails that we are concerned about. But with that, I will try and pick up as many of these new points as I can, but I am constrained in my ability to do so for the purposes of today. Some of the points were raised for the first time in the skeleton argument and supported by documents that were put into the bundle yesterday, and my learned friend takes them to you today. So again, it is difficult for me to give you comprehensive answers to some of these points, but I will try my best to do that and pick them up as I go. Very briefly, the first issue, should custodians be settled today, or should there be some further phase in the future when they are settled later on? The claimants want to defer demands for 14 custodians without prejudice to their right to raise them again at a later unspecified date. And then my learned friend has alluded to it just now. They want a lot more information from which they say they would be able to identify further custodians to add to the pile of custodians that they already want. The identification of the custodians is a crucial first step in the process to ensure that the disclosure exercise is done properly and efficiently. Drip feeding custodians will cause all kinds of havoc at various stages, and in particular at the TAR review. So we would urge your lordship to fix the custodians now and not countenance sequential requests for custodians.
What do you say about the fact that they've asked you for information that you haven't given?
I don't know what the answer to that is. That came as one of the new points that was raised in the skeleton arguments, and I'm waiting for instructions in relation to that. So I will find that out for you. But in relation to, for example, to information about quantum, our understanding was that we took you to the CMC order. So the case management order, remind myself, and I'm catching up myself, but you saw it, I think it's page 431.
Yeah.
430, paragraph 16 of the order. The experts on valuation of the claimant's business quantification of any loss shall meet for the purposes of identifying documents that they require and the methodology for their reports. And then what we had anticipated was that within a short period thereafter, there would be a specific request for documents, if necessary, by the claimants to the defendants. And that was how those sorts of documents were going to be dealt with. Now, in practice, that, as I mentioned at the outset, that sort of information needs to be extracted at the Swiss level, because it is not possible to extract from data in relation to a client, well, specifically the client data, just client data alone, the amount of revenue that comes to the fifth defendant as a result of that, particular client, because it is not just the revenue. What happens is the revenue goes to the Swiss entity, and then there is a profit calculation associated with that revenue, which then leads to a retrocession that is paid back down to the DIFC entity. And so really the only efficient and sensible way of doing that is by interrogating the banking system in Switzerland, and that is what we had envisaged would be undertaken. So you'd have requests and inspection of that banking system. Now, if necessary, we could have that interrogation of that system be done under the supervision of the experts, for example. There are ways that we could resolve that, but it had not been anticipated that we would be including large volumes of custodians and in particular client documentation, which would be the source of a sort of general disclosure exercise, which would lead to quantum being determined in that way. So that's how we understood all of that. I'll come back to, if I may, to the other points that are being raised.
I don't think any of that featured in the rationale for particular custodians that was put forward here. Is that right?
Yeah, no, it didn't, my lord. I mean, we saw that as a separate category, so I wasn't putting that forward for the particular custodians that we've identified.
Yeah,
not for the particular custodians, but this is for the follow-on information and one category.
Yeah, no, I understand that. Yeah.
So this was my point that so because the reason we're talking about this is because I'm making my preliminary point, which is we need to settle the custodians now. Well, my learned friend's got a series of questions, the answers to which he says will lead to further custodians. I was just dealing with one category of those questions, which is the questions that go to what I'd refer to as quantum custodians, if they exist. But that's not how, as I understand it, the parties had anticipated that those issues would be dealt with. There are one or two others. I'll come to them if I may. Internal investigations was one of them. And so it said, well, you haven't given us the information in relation to internal investigations. But the question about, because we say there weren't any internal investigations, save for the audit that my learned friend took you to. Now, in relation to that, if we go to, I think it's page, is it 2520? Sorry, I don't have that, so I'm slightly out of order. My notes. The audit report is at. Bear with me, my lord. Yeah. Is it page 2522? My lord, if you have that. So that the particular request in relation to that is we want custodians of documents related to internal investigations and discussions with regulators. We say, well, there weren't any apart from this one. My own friend characterizes this as an investigation of the very conduct which is the subject matter of the claim. That's what he said in his oral submissions. It's nothing of the sort if you look at it. Apart from anything, can I just pause at the top right of page 2522? My own friend says that color coding or that numerical coding is a grading system by which the DFSA graded my clients for their compliance or otherwise with.
I'm afraid to, sorry to interrupt. I didn't say that. This is an internal document. It plainly isn't a DFSA grading.
Right. Okay. Well, the grading though doesn't run from A to D, as seemed to be suggested. The grading is D to A in the sense that D is green and C is needs action but isn't particularly urgent. If you're at A, it doesn't mean you're doing very well. It means you're doing very badly and something needs to happen very quickly. And you can see that from the following page, 2523, in the middle of the page, where it says, we conclude that management on site in Dubai are well aware of the pending issues to be addressed. We therefore class our report C in respect of the internal controls and so forth. So it's not a bad report. It's a report saying it's fine, it's in hand. And it's going forward. But it is not about the selection or the approach to clients. It is purely about the processes which were in place to secure documentation with new clients as they are onboarded. It is a procedural investigation and audit, or an audit of procedural and compliance functions. So if you look at the one paragraph up from where I've just shown your lordship, you'll see what it's about. The DFSA in October 2014 performed a first risk assessment on BJSSAME. That's a standard thing for a new entity. The final report was issued and so forth. I'll let your lordship read that.
Yes, I'm not sure there's much between you really, but go on.
No, but what's being suggested by my learned friend is that this is an investigation of, quotes, the very conduct which is the subject matter of this claim. The subject matter of this claim is, relevantly, as I understand it, the alleged, I'll put it in these terms, poaching of clients. This is not about approaches to clients. This is purely about the logistical operations involved in onboarding clients. And if one looks at the headings, it's all entirely procedural. So what's being done is basically it's being said, well, because there is this audit report, that's indicative that there was an investigation into the sort of conduct that is alleged in these proceedings, that is approaching clients and so forth, perhaps breach of fiduciary duty in doing so. That is not what this audit report is about. And so when my learned friend says, well, we've asked the question and we haven't been provided with any list of custodians, what he doesn't say is that he's asked the question, give us custodians about investigations. And we've gone back to say we don't have any investigations of the sort that are being alleged. And therefore there are no custodians. That's my understanding of my client's position in relation to that. It's been asked, we want, what's a couple of other points that are sort of ongoing further, identification of further custodians. The first is document, the second one after the internal investigations is documents in relation to joint venture companies. That was the next one. And the position in relation to that is that the joint venture companies are not relevant to the scheme that is alleged. And in any event, I mean, the way in which that category is described is impossibly broad. Documents, so we're being asked to give them a list of custodians, quotes, who hold documents, quotes, in relation to joint venture companies, of which there are a number all over.
Well, I'm looking at the draft order, Mr. Montague Smith, which is, I think, probably what you should be looking at, and paragraph 3, which is what they're asking you to identify custodians of documents in relation to, and then the categories are set out. So this one refers to the closure or winding up of Sarasin-Alpen LLC, Sarasin-Alpen and Partners Limited, and it lists various companies and the movement of relationship managers and clients. So that, I think, is what you should be looking at, as opposed to a more general form of wit, which I think you've been addressing.
Yes, well, I took it from Skeller's argument, which was how it was paraphrased.
Yes, yes. Well, there is a degree of precision in the draft order.
What we are being asked to do is identify any person who holds documents relating to all of these events. So the closure of Sarasin-Alpen.
Yes. Well, yes.
And all of those entities. And one has to ask the question, I mean, that's the entire organization, presumably. It's all of those, it's going to be an incredibly large and broad category of custodians that we're being asked to undertake and add to the list in relation to that. But I will find out more about this, because from my instructing solicitors. And in relation to the 3.3, the making of a provision or not for any adverse liability in relation to the claim brought by the Carafi family against the first claimant and the fourth defendant. I think the short point in relation to that is that the only relevant provision would be provision in the first claimant's accounts, because it's that provision that gives rise to the liability that it said was seeking to be evaded. Provision in the accounts.
Well, no. Well, I'll think about that, but I was just wondering whether there might be provision in parent company accounts in relation to subsidiaries position. I don't know.
But
anyway, it bears thinking about. I don't know, and particularly, of course, in the context of what actually finally happened in the judgment.
But there might be provision. I don't know at the moment whether there would be provision or not in the parent company in relation to its direct liability.
Yeah, but also in relation to its subsidiaries' liabilities, what I was wondering. I don't know is the answer.
Imagine that there would be any prospect of that, though. I mean, a parent would not carry this. It's not a subsidiary either. There we are, I'm told. So.
Well, it's a part subsidiary, isn't it?
It was at the time, wasn't it?
It's a joint venture company, 50-50, wasn't it?
Sorry, that is correct. I thought it was. But I mean, one can see that there might be parent company guarantees and so forth, but it would be those that would generate the provision. And that would also eviscerate the whole point of the alleged scheme, because they could just go to the joint venture company for the cash. Sorry.
No, I understand that.
Yeah. So I'll perhaps come back to you on the second category, if I may, at some stage, if I get a little bit more information in relation to that. But I think primary.
I mean, the point is a fairly general point here, Mr. Montague-Smith. In the ordinary way, you'd expect the parties to correspond about this,
Yes.
and for your side to be saying, well, actually, these are very broad categories. If we're looking for what's relevant to the dispute here,
Yes.
then the only types of document that will exist will be these, and they will exist in the hands of this sort of person. It's the sort of preliminary, isn't it?
I'm told that all of this has been discussed in meetings.
Well, I don't know, of course.
No, well, you don't. But I think, unfortunately, the way that this is being done means that all of that's going to have to be written down, and all of that cooperation and speed, which we'd hoped for, is going to be rather trammeled by bureaucracy. But that is where we are, because there is quite a stark difference between what has happened up to now. But let me I think the point from our perspective, my learned friend says there's no kind of submissions or evidence about cost and all the cost of this. That is of course a concern, and obviously the more documents that we end up with having to search, the more it costs. But the primary concern is about the time that it is going to take to do this exercise. Now, the estimates that I've given you were on the basis of a sort of 40 custodian approach. Where we are at the moment, I think we originally offered 26 custodians, and the offer that came back, or the demand that came back on the 4th of June, was about 50 all in. By the time of their letter in September, they were up to about 80, albeit 14 of those have now been deferred. At the moment, and you can take this from my skeleton Appendix 1, which I think is agreed, we have agreed to provision of 39 custodians as a collective number. Mm-hmm. In addition, I think we have agreed to search for Bank of Singapore relationship managers within the confined terms and add those to the list of custodians. What is being asked for by the defendants is 21 additional custodians, 14 further custodians to have decisions in relation to them deferred. So that's now we're up to 74 custodians in total. And then we have these broad categories of custodian request. You're not being asked to add anybody else to the list today as a result of those 4 requests. They just want the information. But it's trailing that it's going to get significantly larger. Our main overarching concern is that in a large part, the custodians that they've identified will have duplicative or overlapping disclosure of documents. So, or that it's highly unlikely that relevant documents which are not already picked up in searches of existing custodians will be picked up by adding further custodians.
Well, I have a slight issue with that, particularly where we're talking about board members. Of course, if board members have hard copy documents, they may make notes on them. Sort of thing a board director would be expected to do is when he receives his package of board papers, he makes manuscript notes. If it's electronic, then he may make highlighted notes and so on in an electronic format. I mean, that would be fairly common practice, but so it doesn't necessarily follow, does it, that what is in a package of board papers is going to be identical between all board members?
No, and look, I accept that as a conclusion. Of course, unless you have every single person who had any contact with this and search all of those documents, sure, there may be things that fall through the gaps. Of course there are, but then you are into the millions and millions of documents. The question is what is proportionate at this stage, and we do say that one has to keep a sense of proportion. Otherwise, we really are. I mean, we're in your lordship's hands. We are concerned about the timescales. But if you order us to do this in a way which produces hundreds and hundreds and hundreds of thousands of documents, we're just going to come back to you and say, hopefully with some evidence, this is the way it's gone so far, and this is what's going to take. And we're now looking at a trial at the back end of 2026 because the document disclosure exercise you've ordered us to do, and here is the evidence, will take 9 months. Now, I'm trying to avoid that at this stage, and I hope your lordship is trying to do that as well. Now, I mentioned this at the outset, we are well outside the ordinary approach to disclosure and production in this court. Of course, I understand why we are outside that, but one just has to bear in mind that that's the starting point that we come from. We are well beyond that, and even in England, where we're still we are struggling in England with the multiplication of documentation, the proliferation that has arisen from electronic communication, which commenced well before the events in these proceedings. So the question is where to draw the line in a situation where you've got diminishing returns. And so it is worth bearing in mind that if you have, as we do, for example, 5 board members from this entity, adding another 3 board members because they are board members is very unlikely to really add much other than time and expense. That's the sort of one of the central propositions that
I understand that, but the one thing I do concerns me in a case like this is that if there is, quote, a scheme and a plan, it's exactly the sort of thing which is not on formal documents, but maybe the sort of thing that people note in one shape or another. This is the real problem with the fraud case, isn't it?
And I understand where you're coming from. My understanding is that the real concern is about the notation on documents, electronic and hard copy, which can be found in repositories, as opposed to the correspondence. And if that is right, then it may be that we can have a class of custodians for those particular types of documents, which will be much lower in volume. I'm not offering that forward. I'm not in a position to do so. I don't have instructions on that, but that would be one way through it. The real proliferation of documents is in the email traffic, where you have individuals who are receiving hundreds of emails every single day over years. And the duplication involved in that and the volume of data concerned with that becomes very, very large indeed. Now, of course, there may be an email in there that particular one, that maybe the scheme there is a scheme and it doesn't come across in all this other email documentation that you've got, which is networking between, in some cases, 5 board members on that board. And yeah, maybe there would be that one nugget that appears from that 8th board member. But the whole point of the exercise is not to say that's the test. Could there be? It's what's reasonably likely at this stage to be in the position. But one can distinguish, I think, between categories of document, emails on the one hand, and then just electronic or hard copy repositories on the other. You're right that this is the kind of issue that ought to be discussed and agreed between the parties. We have repeatedly asked for specific explanations of why these additional custodians were required. There are examples of that in the bundle, and give them to you for your note if you'd like them. But the reasons that we've been provided with to date have been very, very brief. Now, we have sought more detailed reasons, and they were effectively just repeated again, the ones that we already had in the 13th of September letter that we got, 10 days ago now. And what you have before you today is a lot of new reasons that have not been added before. And we don't know why these haven't been raised before, but the result of that is that we have not been able to consider the points that are being taken and alternative solutions to the points which are being taken. For example, where the sole basis of seeking to include someone really is that they were on the board at that time, then perhaps they can be replaced by someone who serves multiple functions, and you can, in effect, deduplicate the custodians in a sensible way. And we haven't been able to do that because what we're just getting is layering on of more custodians and more reasons. In correspondence, custodians were overwhelmingly identified because of the positions they held. And our overarching point, as I say, is that there's, subject to your lordship's point and subject perhaps to hard copy and specific documents, there's little additional benefit of having further board members of various entities and various committees. Just to tell you what we've already got, we have already agreed to include as custodians board members for BSA, there are 3 of them, BJSS, 2 of them, BJSSAM, 5 of them, JSSH, 2 of them. In relation to the committees of BJSS, we have already got 4 custodians who were on the executive committee and 2 custodians who were on the credit committee. And there is coverage across the whole, we say, of the relevant periods. In addition, Mr. Walia was on the BSA board throughout, and the claimants have access to his documents. Mr. Phillip was a secretary to the board of BSA, and he will therefore see the vast majority of what comes across the board members' desks in relation to that. So what is being sought, and there is some overlap between these, what is being sought essentially is further officers on each of those bodies. So in relation to the boards, on BSA there are 4 further officers sought. BJSS, they want another 7. JSSH, 6 more. In terms of committees, on the executive committee, they want 4 more members, and the creditors committee, 4 more members. Again, there is a little bit of overlap. So those last 2 categories, for example, in terms of individuals, are identical. What I was going to do, so that's our overarching point, that there are diminishing returns if the justification is principally the board membership of those individuals. And we are in your lordship's hand. It's not right that we are protecting certain individuals. It's not right that there are particular individuals in relation to whom there are particular sensitivities. It is about keeping down the overall volume of documents to something that is reasonably manageable. I think the best way to do this for the rest of this is just to literally run through my learned friend's submissions, starting at paragraph 42 and onwards on page 11 of his skeleton argument, and tell you what I say about it as quickly as I can. The first one identified is Ms. Myrene. This is because she was the person who carried out that audit that I took your lordship to, and that my learned friend took you to. And as I've said, that is not an audit which, my learned friend put it, examines the conduct which forms the basis of the case. That is about compliance with procedures. And you can see that from the report itself, and we won't go back into it. That's the basis on which her inclusion has been sought. Really, it's about that audit report. We have only, I think, had her search terms since 16th of September. In fact, the search terms that are being sought in relation to her, I know it's a slightly different issue, but they're very broad. So we would just say if she is to be added to the list of custodians, she should be added for that narrow purpose, for her involvement.
I think that follows on almost every case, Mr. Montague-Smith, that in every case where one's looking at an individual, it's a question of identifying what the appropriate search terms may be. They may be different from one category of person to another. That seems to me obvious. Yes,
I think that's right. But it's not just a question, not for now. It's not just a question for if you go, as we say, there are certain individuals who they just should be excluded altogether. B, if your lordship's not with me on that, then some degree of indication about how that search should be circumscribed would be of assistance at this stage, because otherwise we're going to get into a long and difficult argument about all the other search terms that there are. So that's I wasn't really going to say much more about Ms. Myrene. My learned friend says this is symptomatic of how unreasonable we are being, but in reality, what she's been brought on to do is look at a very specific DFSA audit requirement and implement it and ensure that onboarding processes are up to scratch. That's got nothing to do with the subject matter of this claim. And if your lordship thinks, well, there might be something in it, then it should be limited just to that audit, because that is the basis on which her inclusion is argued for. But we say, well, actually, there's nothing to suggest there is anything in it. Certainly, it's not unreasonable. The next person is Philip Meyer. Mr. Meyer was a director, but he wasn't on any board. He's not a director in the legal sense. Your lordship will know, within the context of banks, banks give titles like director to non-fiduciaries in many cases. He was a member of the in-house legal team. He's not an authorised individual. He's not said to be involved in the scheme. It is said that his relevance is that he will be able to shed light on the purpose of BJSSM, but because he had interaction with the regulator. And our point is, well, you can see what the consequence of that interaction with the regulator was, because it's all in the regulatory plans. And my learned friend says, oh, that's a lawyer's point. But if it's not said that Mr. Meyer is involved in the scheme, if in fact the evidence is that he's a lawyer in-house who's dealing with the establishment of the company and dealing with the DFSA for that purpose, then why would you think that there's a whole load of documents that would be of relevance to this claim? You already have two of the defendant's legal counsel among the custodians, that's Mr. Astruc and Mr. Greeby, and you also have documents from Mr. Cunningham, who was the managing director of BSC, which deal with the purpose of this company anyway. And that's all before we get to the question of privilege, which we can park for now. So our position, if one thinks about an in-house lawyer, and if one thinks about harvesting that lawyer's data and what that's likely to produce, and the volume of documents and the volume of data, it's going to be very significant if we have to add his data to the custodian pack and then make searches of terms like Dubai, termination, transaction or role, and things of that nature. The next one, paragraph 45, and I'm moving at pace, Mr. Philip. And the point about Mr. Philip is that the allegations against him all relate to the period when he was employed by BSA. So he did not, as I understand it, and I've been told I'm wrong about this, but my instructions are right, he did not join BJSSAM until March 2015. 14, sorry, I am wrong about it.
That's 15, yeah.
No, it is 15 then. Yeah. For example, my learned friend said he was at BJJ SAM when the onboarding took place, and that's wrong. He wasn't. He didn't join them until March 2015, and BSA, as we know, terminated its last clients on the 30th of September 2014. So the documents that he has will be available to the claimants because he was the claimant's personnel. Now, it has been said for the first time in a skeleton argument that he was the company secretary of BSA after he left and joined BJSSAM. I simply don't know whether that is the case, and we haven't had a chance to investigate that because it was raised on Friday and there were a lot of other points to look into. If and to the extent there's anything in that, then any disclosure in relation to him should be limited to his role as company secretary for the period that he was company secretary after he left as personnel. I think that has to be the right answer. Paragraph 46 is Zubin Maria. Mr. Maria was Sarasin-Alpen Qatar's compliance officer. There is some suggestion. So he's not one of our custodians. We don't have his documents. He was employed by a different entity. One of the points that was made in submission, I think, was that he was subsequently employed by the fifth defendant, but he was employed by the fifth defendant between 2019 and 2022. So quite what he can share, what his documents as a D5 employee can shed light on is difficult to know, and indeed there will be none. I think there was also suggestion that there was an email which referred to, quotes, Zubin's documents. Again, I don't know what the answer to that is, and I suppose we can check that if necessary. And it's almost certainly going to relate to 2019 to 2022. That's Zubin Maria. Paragraph 47 deals with a group of custodians which were discussed by my learned friend. So Mr. Sherman, Mr. Graff, Mr. Poser, and Mr. Seven. And this is on the basis, their inclusion is justified on the basis that they were BJ SSAM directors. Subject to your lordship's reservation, then I won't repeat it, but just so you know, we already have 5 agreed, as mentioned, 5 agreed custodians who were also BJ SSAM directors. They are Mr. Cunningham, Mr. Clinton, Mr. Carton himself, Mr. Bookshi, and Mr. Sassoon. As I understand it, Mr. Sherman was in fact only a director from May 2015. So I won't repeat the sort of overarching point I have in relation to the utility of expanding into those. Paragraph 48, we've got another group of people who are identified as being relevant because they were BSA board and BJSS credit committee members. And these are the ones, Mr. Saracen, Mr. Gutz, Mr. Wild, and Mr. Weinberg. Now, at the outset of his submissions, my learned friend said, well, there's an independent legal entitlement to these documents in various ways because they're agents. And so he should be entitled to them as a matter of right. That's not what you're dealing with today. He can make that claim if he wants to. He hasn't yet. I mean, it indicates he could have made it in the last 10 years while this liquidation's been ongoing. But for the purpose of today, the question is, within the confines of these proceedings and the timescales that we have to deal with, is it sensible to add these people to the list? The main justification, as I say, is they're on BSA board, so the same points arise. We have 3 BSA board members as already agreed custodians, Mr. Astrup, Mr. Sassoon, and Mr. Corsetti. And from the credit committee, we have 2. We have Mr. Muller and Mr. Sassoon. The other points to make are Mr. Saracen and Mr. Wild resigned from the BSA board in December 2012. So before the scheme is alleged to have been conceived in about March 2013. Mr. Gutz left in June 2014, but none of these people are said to have been in part of the scheme. Paragraph 49 is Mr. Weinberg appears again as a result of a later stint as a BSA director from 2015 to 2016. Again, we already have Mr. Astrup and Mr. Corsetti, who were BSA board directors during that period. And that is some time after the scheme is said to have been achieved. Paragraph 50 doesn't identify any individuals, but trails that the following individuals be justified as their positions with BJSS and JSSH. So the same overarching points arise. Firstly, paragraph 51 targets the executive committee of BJSS. So 4 people are sought here. There's overlap with the last category because they're looking for Mr. Saracen, Mr. Gutz, Mr. Wild, and Mr. Sherman. Again, we already have 4 executive committee members covering the entire period in Mr. Muller, Mr. Penchas, Mr. Yip, and Mr. Sassoon. There is then a lot of argument that follows paragraph 52 about Mr. Sherman specifically, most of which is new. Firstly, if we go to paragraph 52, it said because he was the chief operating officer of the JSS group, but there are already custodians, including Mr. Sassoon, the executive committee, the BJSS board, the credit committee, so that it's well populated with people in senior management roles at that stage. Paragraphs 52.1 to 52.3, we've got a series of new points which were raised in the skeleton for the first time. And this is where documents have been asserted. You will look at those and decide whether or not they lead to some sort of trail of inquiry which justifies wholesale importing these people in as custodians. The idea that they were involved, for example, in discussions between BSC and Alpen in 2012, relating to the future of the joint venture in a very broad way. I mean, again, if that justifies the inclusion of this individual, well, how many more are we going to be adding in at a time when this is before the scheme was even conceived? That there is talk about discussions of legal fees in the Carafi proceeding and how they were going to be apportioned. These are just normal functional things. They're not indicative of any approaches to clients. And Mr. Sassoon negotiated on behalf of Alpen and so forth. There are inferences being drawn for the first time in skeleton arguments, and we say that's not an appropriate approach to make. If we move on, I mean, one of the central points that's made is paragraph 53. It said, well, Mr. Sherman was on a lot of these different groups, so you can kill a number of birds with one stone in a sense. But as I say, if it's right that there are already people who are covering off those particular roles and those particular bodies, then his addition adds nothing. And perhaps the better approach would be that deduplication, to have someone like Mr. Sherman instead of a whole raft of other people who are there to sort of make sure that you have coverage of all of these boards. Paragraph 54, it's justified on the basis that he was an executive committee member. So again, we've already got coverage. And 55, because he received the internal audit report, which I've taken you to. In relation to that, just one point to note is that audit report it went to quite a lot of people, 6 of whom are already custodians that have been agreed. So Mr. Breaker, Mr. Sassoon, Mr. Muller, Mr. Akstruck, Mr. Bookshi, and Mr. Swan. There's a new point raised in relation to a document at page 3171. Again, too late to take any meaningful instructions, at least for me. But reading through that, what you have there is Mr. Phillip, while employed by BSA, you can see that from his Bank Sarasin-Alpen address, consulting about the messaging of what to tell people in response to the adverse judgment. And what one knows within an organisation, that's an entirely standard thing to do. Well, there's no significant adverse judgment that goes without a press release. And clearly what is being said to regulators and to clients by relationship managers is something that needs to be coordinated. And there's nothing there that's indicative of some sort of involvement in the scheme, and indeed that isn't alleged as far as I'm aware. So we say it should be enough to have board members, executive committee members, credit committee members who cover the relevant period, and that if necessary, there could be specific and targeted disclosure requests. And we've suggested that in correspondence, and you can find that at page 2671 of the bundle if you want to look at it. And we've been told that and we've said that we will consider requests of that sort. Paragraph 56 then moves on to justify various other individual custodians that are sought on the basis that they are members of BJSS's board. And so the same point stands. You have board members. Of these 7 people who are listed here, so you'll see it's Mr. Sherman, Mr. Safra, Mr. Dupont, Mr. Haim, Mr. Schatt, Mr. Hufschmidt, Mr. Voll. 4 of them do not have J. Safra Saracen emails. I need the list of that, don't I? I'm so sorry. I'll give you the list of those 4 people in due course. So those people will not be within defendant's control. Their documents are not in their control. They're independent directors appointed to the board. In relation to paragraph 56, the rest of it is focused on the status of these people as board members, to indicate that as board members they would have received various categories of documents. But again, that doesn't take one further, or doesn't add utility to the existing custodians that there are. Paragraph 56.2 raises a particular point about decisions being made. Yes, thank you. So the four J. Safra-Sarasin, the four directors without J. Safra-Sarasin email addresses are Mr. Verl, Mr. Hufschmidt, Mr. Dupont, and Mr. Schatt. These are independent directors and work for us. But I would just
what does that mean, Mr. Montague-Smith?
It means they can't. Their data cannot be collected as custodians for search.
But when you say they're independent, I mean, does that just mean they're non-execs, or what does it mean?
It means that they're not employed. They're based at other companies. So, for example, Mr. Dupont is based in Luxembourg at an asset management. A lawyer. He's a Luxembourg lawyer, for example, and he sits or he sat on the board of the company for a period. He was one of the nominated. So it's similar to in a non-executive role. I wouldn't necessarily. I don't know whether or not it's analogous to that, but they were not employed by us at that time. And so they were not operating from J. Safra-Sarasin email addresses. So in practice,
no, I understand that point.
So the basic position is, if one thinks about what we're being asked to do here, we're being asked to add these people as custodians and therefore harvest their data, bring that on board, and then apply search terms to that. But if it's not our data, we're not entitled to it, or it's not segregated in a way that we can get it.
But the point that arises is, if one's going to come down to the question of control, on the face of it, one would think that every director's documents are subject to the control of the company, because they, as I think effectively Mr. Shivji said, they owe duties. The documents that they obtain in their capacity as directors are within the control of the company that can ask for them.
Yes, understood.
I mean, I agree they may not have their documents physically in their possession, and certainly they don't have an email address. But
understood.
If one's going to be technical about it,
I understand your point.
They could acquire them, probably by lawsuit if necessary.
My point is more a practical one.
Well, I understand that.
Which is this: that what precisely are we going to do to get those documents in? So
you have to ask them.
Yeah. And then what happens? So it's not going to be integrated into the procedure that the parties have been discussing, which is capture data by reference to custodian, add it to a database, process it, search it, and then do targeted searches. The similar issue arises in relation to Herbert Smith Freehills, and I'll come on to that in a moment. But it may be different because there may be segregated documents, depositories in Herbert Smith, where they can just pick it up and pass it to us, assuming that we've paid our legal fees. But this is an independent director who's sitting in a law firm in Luxembourg, and one of them's in Germany, I think, one of them's in the Netherlands, sending emails from their own law firm addresses, a bit like me sitting on the board of a company and sending from my chamber's email address, and then I receive an email 15 years later saying, I want all of your documents relating to us for the period X to Y. It's not a practical process that can be undertaken by us. You can tell us, I expect you to go to these people and ask to provide your documents. That would be plausible. But all of this feeds into the question of what are the returns that you're going to get out of that sort of complexity and process. And this introduced this late in the day. Because we've already got these BJSS directives in place. Paragraph 58, Mr. Dupont is also justified as a custodian on the basis that he received the audit report, I think. But as I've said, we've already got 6 other custodians who did. Paragraph 60 deals with various individuals on the basis that they were on the JSHH board, sorry. And 7 people are sought. And the point there, again, we already have 2 who cover the period. Mr. Breaker and Mr. Penchas. Paragraph 61, sorry, deals with Mr. Jacob Safra. And there's a new point arising in relation to, out of some of these emails that are relied on, and in particular, an email which appears, I think, at 3087, suggesting that there might be a meeting between Mr. Safra and some of the clients of the bank. But you will note that that was a draft, as I think email. It said 3079, sorry. We don't know whether it was sent, and all it does, and Mr. Safra is intended, I think, to be copied on it, but a number of other custodians are also identified on that email. So these discrete points that are being raised, we say that they just don't justify the sorts of wide-scale importation of custodians that is being suggested. Then we get to paragraph 63, which is the Herbert Smith Freehills custodians. And again, it's not really been explained how this is supposed to work, because Herbert Smith Freehills are not directly under our control, and presumably they're saying we should get them to send all BJSS documents to us so that we can include all of those documents.
I'm struggling really to see how anything they have is going to assist, really.
I agree, and because any advice they've given us is either privileged, or if it's not privileged, we've got it. So it's going to come out of other. What's being said against me is that there are some letters that have been sent by Herbert Smith to third parties, and somehow those might not be caught by documents. That seems extremely unlikely. It's vanishingly unlikely, because the idea that Herbert Smith is sending out documents without copying them, without sending them also to their client to show them what they're communicating, seems to us to be extremely unlikely. So everything that Herbert Smith has will, we say, be captured, either as drafts or as final documents. And just pausing there, I mean, one has to just pause and think about the impact of that. You would be asking us to go and force Herbert Smith to produce documents in relation to a mandate that took place, 11 years ago, and so that they could be produced in litigation before the court. It's quite an extreme response, we would suggest, but there we are. My Lord, I think that covers off all of the categories that are being requested as specific custodians. And then there's just the question of the further categories of the further categories of information that are sought, from which one might identify that, the further custodians. But ultimately, this is not about trying to make life difficult. We've offered up 39 custodians. There's going to be a massive amount of data in that. We've been calculating about it. It would be quite some gamble to give up all of that. That is not what is going on here at all. It's about trying to keep this in bounds and trying to maintain the trial date. Anything else you want to? My Lord, unless there's anything specific you'd like me to do my assistance on further, I will there.
No, not for the moment, thank you.
My Lord, I've got a few short points, if I may. So just putting all of this together, this is all about ensuring that the DIFC court is effective in combating fraud. This case is going for a long-awaited and expensive trial before your lordship next year, and the aim is to ensure that relevant documents are before your lordship so that your lordship can determine this case fairly. That is the guiding star to deciding which custodians are in or out. It is not a numbers game, as my learned friend suggests. It is a matter of trying the best one can to identify by reference to the evidence which individuals were most closely connected with the issues which your lordship will have to determine. Now, in terms of the materials available, I think we probably all observed over the course of our careers that in modern times, emails are a very good source of understanding what people were up to at a particular time. They're a good contemporaneous record of people's activities. They are far more illuminating than a set of board minutes or board papers. And so if your lordship is going to have insight into what particular individuals were up to, your lordship will need to see their emails and possibly sometimes their phone recordings as well. Now, your lordship has seen enough of the history of this litigation to sort of perhaps get one's eye in as to where we are and why we're here. But it is striking the amount of effort that the defendants are putting in to resisting particular named custodians, as opposed to the efforts that they put in progressing their disclosure exercise. And in fact, if the resources have been deployed against us today to be deployed in a different direction, they might be further down the track. We heard from my learned friends during the course of his submissions that what we were asking for would add, I think the submission was millions of documents, and at one point here he said hundreds of thousands of documents. That's what my note says, but we just don't understand where these figures have come from. As I understand it, my learned friends solicitors have not got to the point where they have captured any of these custodians' data or examined how much there is. And of course, the whole exercise needs to be focused and proportionate. So we're not talking about going off and imaging Herbert Smith's emails or asking for every custodian's emails over a long period of time. This is all about trying to identify the protagonists and making sure that their documents are before your lordship to illuminate your lordship on what happened. Now, so much of my learned friends' submissions focused on the point that we are asking for the document of custodians who may well sit on another committee or board with existing custodians. And that really, when he went through all of the categories, he kept coming back to that same point of saying the number of custodians we had from particular boards or committees. But that overlooks the critical question. It's not what committees these individuals sat on, it's what they were doing in their day-to-day jobs, what meetings they were having, discussions they were having outside those committees. In a fraud case, it is highly unlikely that a fraudulent or dishonest activity would be minuted and recorded in a board meeting, may not even be discussed directly in the board meeting, but it's those discussions outside the meeting with the executives that are going to illuminate what was really going on. And one can easily think of many boards where there is also essentially different levels of activity across the board. There'll be non-executives who will have very limited involvement and other executives who may be a specialist in a particular area or tasked by the board to go and research something. And looking at the categories of individuals that we were earlier, we were looking at heads of private banking, heads of family office, Mr. Zerman, who's the chief operating officer, and we know operationally was dealing with both fifth defendants, CRMs, and also inquiries from Mr. Phillips about messaging from my client's CRMs. So one can see, actually looking at the day-to-day functions that individuals were taking, that some important protagonists are not currently in the defendant's custodian list, and they really ought to be. Now, just a couple of final points. First, my learned friends seem to be saying it was all very difficult with the independent directors to get their documents. This sort of issue comes up all the time. Your lordship may have come across the phones for EU case, which concern this. I mean, the simple point as a matter of law is, as a principle, I'm entitled to ask my agent for his documents in the discharge of his agency. That doesn't mean some sort of very elaborate, complex disclosure exercise. In the first instance, you ask. You've set up a sensible way for a search to be conducted. None of that is difficult or impossible to achieve. And the same goes for Herbert Smith. I mean, the point that we made was that we know that Herbert Smith handled the correspondence in certain issues, for example, the DFSA, and we want to make sure that that correspondence has been captured. Now, my learned friend says, oh, well, you'd expect the bank to have a copy, but the bank's contact with Herbert Smith, Dr. Philippe Mayer, who was the person who instructed them, they don't want as a custodian. They've resisted his inclusion as well. So that's how you end up with a sort of number of different magic tricks across the various individuals, suddenly sweeping away key areas of the board activities across private banking, across family office, across operations, with the result that your lordship doesn't have visibility on exactly what the bank was doing at the relevant time. And then finally, my lord, just on there was some discussion with my learned friend about provisions. And as I understand it, the fourth defendant's position is that there was no provision in its accounts in relation to the Carafi litigation, if I've understood the submission. But we know from the contemporaneous documents that there was. One can see that in the bundle at page 3095. And that's the fourth bullet point. And it says there, BDSS has made a provision in its accounts for its exposure to the claim. This is the Carafi claim, although as yet BSA has not yet done so. And then it goes on to talk about the insurance policy. And that provision, we say, is important because one of the issues in this case is what the defendant's assessment was of the prospects of that litigation, the prospects of losing, and whether they knew that they, as we say, that they faced material risks in that litigation, such that it went to whether or not they were defrauding creditors in their activities of divesting it of business. So the exercise that was involved in setting the provision would have involved some assessment of the merits of the claim and the exposure. And given it was a claim against both the fourth defendant and my client, that analysis for the fourth defendant would also be relevant in assessing what the position was for my client. So that, again, is sort of classically something that's obviously relevant. It could be easy to identify, and but the defendants are throwing roadblocks in the way and saying it's all very difficult to identify custodians. And your lordship is entirely right that what normally happens is the parties have a sensible discussion about how to attract a particular type of material, and they craft some bespoke search that captures the question. It doesn't have to be some complex or overarching disclosure exercise. My lord, just one final point. My learned friend spent a lot of time on the audit report saying that it was about something different, but I don't believe I misstated what the audit report exercise was about. It was an analysis of the onboarding by the fifth defendant following on from recommendations from the DFSA. And as part of the analysis of the onboarding, they obviously had to look at how each of those client relationships were initiated. And the report identifies the number of clients and the period that were analysed. And it's clear from the report that that analysis looked at the substance of what happened. Now, of course, it was looked at with a lens to work out procedurally what the recommendations would be. But the analysis looked at the substance of, well, how was each of these clients, how were they taken on board? At what point was contact established? What was the nature of that contact? And then what do we do to put documentation in place? And one can see that, for example, from 2524. So one of the recommendations was that client interaction is initiated only once the formal relationship has been opened. And then the report explains that given that the fifth defendant only has the advisory relationship with the clients and the formal account opening is controlled by the booking centres, controls are in place preventing the transfer of assets and funds before the client relationship has been established. The extent of client interaction in the sense of advisory activities permitted during the prospecting and onboarding phase would have to be addressed in the recommended formal directive addressing the prospecting process. So what that shows you is that they would, in making that recommendation, they would have looked at the interaction for each of those clients during that onboarding time. And the recommendation is, and it's not uncommon for institutions to spot this and say it raises as a point. What they're saying is actually you ought not to have clients interaction until you've formally got the client on your books. But in order to make that recommendation, they would have had to look at all of these cases on the interaction. What was that interaction? And that obviously the interaction must have involved some discussions before formal relationships were opened, which then resulted in the recommendation saying, well, no, you need to have the formal relationship set up first. Now, of course, the focus of this report will not have been where these clients snatched from my client, but it would have looked at exactly the communications that are relevant to this case. And that's the point that I was trying to get home, that it would have involved Mr. Phillips and others poring over how each of these particular client relationships were initiated. And of course, the purpose they were doing that was so that they could get their procedures right. But that analysis of those relationships, that is a key feature that's going to be central to this trial as well. So that's the point, my lord, I was trying to get home. So, my lord, putting all of that together, we say really this comes back to fraud, and whether or not looking at these protagonists, whether your lordship thinks that you need to see at least some of their emails from the relevant period in order to fairly try this matter. And perhaps often this discussion about custodians happens alongside discussions about keywords, and sometimes it's more helpful to do it that way, because the key words are these safety nets to make sure that a party is not overburdened with vast amounts of irrelevant custodian data. And it is not in my client's interest for there to be vast amounts of irrelevant data in play in this litigation, because that will put up the expense for all of us, including us, in having to review it. So we strongly are incentivized to identify those custodians who are key, because otherwise it will just be generating material that we need to look at that's not interesting. So, my lord, unless I can help you further, those are my submissions.
Yes, thank you. All right, well, I'm going to tell you my decisions now in relation to custodians, with just a few opening comments to explain the basis on which I've made those decisions. First, this is a case of alleged fraud, which requires an exacting measure of disclosure, which is why it has been ordered in the form that it has. Secondly, so far as members of particular boards are concerned, subject to the periods concerned, it is not good enough to say that disclosure by one board member or two board members or even a certain number of board members is sufficient when there are others who may indeed have been involved in conversations, whether by email or otherwise, and may have made notes on board papers of one kind or another, whether electronically or physically. So far as non-exec directors are concerned, and I use that expression loosely because the way they've been described here as being, quote, independent, I understand as meaning that they're not employed and therefore are effectively the equivalent of non-executive directors. What they have to say very often is extremely illuminating, because they are less aware, perhaps, of the problems that may surface if they are overt in what they say as opposed to being covert. People who are employed and involved in a scheme of some kind may be chary of making any mention in documents, whereas non-execs may not suffer from the same inhibitions. Their documents are documents to which, on the face of it, a company is entitled, and they can be requested to give them up, regardless of the fact that they don't have emails that are within a domain that is subject to the immediate control of the defendants. All of these various categories of personnel may in fact be subject to different search terms, which sort out what is relevant from what is not, and therefore the burden should not be as extensive as perhaps has been indicated. And indeed, this is a commonplace in matters of this kind in any event. So far as the audit report is concerned, I take the view that there is potential materiality in that. It's quite true that it will have been designed to deal with processes rather than anything else, but there's no question that the onboarding exercise was the subject of investigation, and in particular the possibility of advice and so on being given prior to the actual onboarding taking place in the present case. So with those preliminaries, I then turn to Annex 1, which I think is the easiest way of ensuring that I deal with each of the individuals concerned. That's Annex 1 to the claimant skeleton. So Eric Saracen must be a custodian. Fidelis Gertz and Peter Wilt are not required to be custodians because their involvement is too early in the exercise, on the basis that the scheme is pleaded as taking place from the second half of 2013 onwards. The actual establishment of a company in Dubai is not alleged as such to be part of the scheme, and therefore their involvement in that does not seem to me to be material. Mr. Weinberg should be a custodian. Mr. Mayer need not be a custodian. Mr. Sertzman is to be a custodian. Miss Christina Meyerine is to be a custodian because of her involvement in the audit. The point mentioned that it should be subject to limited searches particularly holds good there. Mr. Philip is to be a custodian. Mr. Zubin Mariah is not to be a custodian. Mr. Graf is to be a custodian. Mr. Poser is to be a custodian. Mr. Seven is to be a custodian. Mr. Jacob Safro is to be a custodian. Mr. Philippe Dupont is to be a custodian. Mr. Haim is to be a custodian. Mr. Schat is to be a custodian. Mr. Huschmidt is not required to be a custodian. And Mr. Joseph Safra is required to be a custodian. Mr. Dagmar Vohl, also a custodian. Herbert Smith, not required to be custodians. I hope I haven't gone through that too quickly, but the transcript will show it in any event.
Thank you, Miles.
That only leaves the question of further information, doesn't it?
That's right.
I have a difficulty with the form of the order sought, but I do think that these are people where there ought to be discussion as to what else might exist. I'm loath in a sense to make an order on this, but make it quite plain that I think there ought to be a discussion between the parties, as ought to take place in any disclosure exercise of this kind. And this is a discussion that should have taken place long ago about what the categories of people are who would have the categories of documents in question, and a discussion as to which of those really matters and is likely to give rise to sensible results that will take the matter forward. So whilst I'm not making an order as such, the parties are going to be meeting in relation to search terms, and they can deal with these matters at the same time. The two go together in any event. So perhaps I can just leave that like that, and if when you come back again, as you will, no doubt, issues have emerged, well, I'll try and deal with those as and when.
Okay, I'm grateful for that, my lord. I'm conscious of the time because it's now, I think, 4:24 in Dubai, and your lordship's been very indulgent with us on the timing. Indeed, has the transcriber and the court staff. I was wondering whether we could just, in previous hearings, it has been fruitful just to run through what the order would look like from the hearing. I know in other litigation one sends the parties off, but to save the court the trouble later, yes, I would rather do that.
Yeah, well, I'm all in favour of making sure there's absolute clarity, and no room for debate about what has and has not been decided.
So
how long is that likely to take? I mean, the question again is, do we take a quick 5-minute break for the transcribers and then just come and sort out the details. It shouldn't take us more than 10 minutes or so, should it?
I don't think it will. So I think that's a sensible idea, because also I could
Right,
just
well,
run
let's just
through my junior.
take 5 minutes, and each party can organise itself as to what they think I've ordered, and then we can go through it and see if we can make sure we're all in agreement about that. So 5-minute break at this point, please.
Okay.
Right.
My lord, I wonder if the best course is to take you through my draft order, which is at 3061.
That's
And
what I was looking at.
I'm conscious that there are some points that are addressed in the skeletons that we've not dealt with today, and in light of the time and in light of your lordship being very indulgent with us on the time, my suggestion would be that for things that we didn't have time to deal with today, the parties can go off and discuss them at their meeting, and then insofar as they can't be resolved, we'll have to come back. We'll have to add them to the agenda. But I think if we start going through those items, we'll add another hour, an hour and a half, and that will probably give everyone a sense of humour failure.
Yes, can I also add this? It seems to me that one ought to be building in, I'm not sure whether we have or not, a series of case management conferences for the future.
Yes.
In large cases, I've often done this, and
Yeah.
if they don't need to be utilised, then we don't utilise them. And I can always use a spare day if it should suddenly become vacated. But if we set aside case management conferences on the basis of allowing for a full day in each case, insofar as we can find dates that work, we should try and do that on a 2-monthly basis or something of that kind.
Yes, I would endorse that. I think 2 months is sensible. And I mean, I think for our part, we know your lordship's diary is busy, so we rather feel that we ought to all try and fit around your diary insofar as you can offer us dates. What's the best way to take that forward? Is it for the registry to give us
the best thing is probably for me to simply tell the registry the full days that I can do.
Yes.
On somewhere between 8 weeks to 10 weeks apart.
Yes, and there is it may not be such an enticing prospect, but there is also the scope for half days, in that sometimes the half day can be used productively. Yes. I mean, parties sometimes tend to find they fit the space that's offered to them, so half day would be better than nothing, I think.
Yes, well, half days, if I'm in an arbitration beginning at 10, then I can do a half day beginning at 8 or something. Well, it isn't quite a half day, is it? We can get 2 hours in or something, because I can do that from the arbitration centre or whatever. Yes. Before I start the day. Exciting.
Not a very enticing proposition for your lordship, but yes, we would be grateful for that.
What I'm saying is that it's possible to do that on a more ad hoc basis.
Right. Yes, well,
anyway, let me examine my diary, and I'll get back to the court and make a series of suggestions. And I mean, it may actually be that, having done that, the easiest thing is simply to have a quarter of an hour call of this kind in order to fix the dates in a way that work, because you can tell me what latitude you've got on each side.
Yes.
All right.
Thank you.
Let's go through your draft order. You might spell my name right in the first line, but
yes, I'm so sorry. I'm terribly sorry for that.
It's all right. It's right in the second line.
Yes, you'd would have thought we've had a fair amount of practice. Anyway, we will fix that. I will so just go to the body of the order, given that the preamble isn't great. Going to the body of the order. We'll insert a new paragraph 1 at the beginning, just to deal with the disclosure direction. So we'll lift that from the 10th of June order and repeat it. So it will read: each of the parties shall provide disclosure in accordance with paragraph 11 of the April order by 4 p.m. on the 31st of December 2024.
Yeah.
So that's that. Then I think on to what is my paragraph 1, which will now be paragraph 2, is the claimant's list of custodians, which is in fact agreed already, so that we will populate that in appendix 1. Appendix 2, we will have the list of custodians that your lordship has just read out, which we've taken a note of. On what is currently paragraph 3, I will omit that from this order in light of your lordship's direction, that we should discuss that and hopefully agree it.
Well, we could, when we come to the bit that deals with meetings for the search terms, there can be a general form of words that goes in there.
Very good. Then moving on to paragraph, what is my paragraph 4, which now becomes paragraph 5.
That's agreed, as I understand it.
I'd just be grateful if my learned friend could confirm that.
Yes, the draft originally only included 2014. I believe, though, because we're providing information, we've agreed to provide 2015 as well. Is that right? So I do apologise. Yes. Yes.
Very good. Okay, so that's a new paragraph 5. That's agreed. Then moving on to the current 5, which becomes paragraph 6. Now, my understanding is that that is agreed, save for what is 5.4. But I'd just be grateful for my learned friend to confirm.
But yeah, I mean, these are the issues that we weren't going to raise because we didn't have time to deal with it. Bear with me.
Well, I mean, as
I understand it, 5.1 to 5.3 is agreed, and according to my note, 5.4 is not agreed.
Yes, that is my understanding. I mean, if it is they're only being asked to provide an update, but anyway, it's for them on that. I don't know.
Well, let me explain, if I may, what the position is in relation to 5.4. The difficulties associated actually with the exercise that's being identified are not insignificant. What we have, and this is why I thought that we were going to leave over issues that we hadn't yet dealt with, but my learned friend is wading into them. I mean, there is a real issue here about the timing of when that can be provided, because we cannot do it by the 27th of September, because what it requires, that's Friday. What that part requires is for somebody to go into the old recordings. So there's
Mr. Montague-Smith, I don't want to stop you, but we're not debating this now. We're just, this is a matter that has to go over, that's all. So unless you're suggesting a shortcut to a full argument,
well, no,
it just
I mean,
goes.
I think my learned friend was suggesting you make this order.
No, I wasn't.
Oh, I misunderstood.
But I'm with your lordship. If there is a shortcut, great, and we can put it in the order. If there is not, then it has to be put over.
I think the shortcut would be, well, I think there is a disagreement about the date range. That's the problem. But in relation to some of it, there is simply a disagreement about the. Other than that, there's a disagreement about when we provide that information. So it may be that this is simply something that can be resolved. We're not far off, but I don't think I can agree to it as drafted.
No, well, then why don't sorry, Michael.
Let's leave it out for the moment, and if it's something that's capable of being agreed in the next 48 hours, it can go into the order. If not, it just stays out for the moment, and you just keep discussing it, and they'll have to resolve it on some other occasion.
Thank you.
I'm grateful, my lord. Then moving on to the current.
That's paragraph 5, isn't it?
That's para 5. So then the current para 6 in the order. That I think your lordship has ordered the 7th of October for that.
Yes.
So that should be that can just be amended to 6 p.m. on the 7th of October. Then with delete. The current para 7, because the parties can go straight into a meeting as your lordship has ordered the following week on the 14th, and that should just simply be a date to be agreed in the week beginning the 14th of October 2024.
Yeah.
And then para 9 is that's on a date, so we'll take out on or after the 14th of October, and we'll just say on a date to be agreed, with a provisional time estimate of 2 hours. I mean, that time estimate does seem quite tight, but on the other hand, the whole day keyword search is not enticing. I wonder whether 2 hours might focus everyone's mind as to whether they really have the appetite for the fight.
Well, you could say half a day just to give yourself a little bit more room. And
Very good. Let's do that.
Just to interject, at this stage, I think the suggestion was that if keyword searching has been resolved at that point, it might be possible to use that as a case management conference more generally, or an update.
Yep.
I don't think that necessarily needs to go into the order, but we can put it in or not as you require.
Can I just suggest? I mean, case management obviously useful, but if any application of import was intended for that, we would need to have proper notice. I mean, I say that
would apply to all the case management conferences I'm going to suggest, so that proper notice is given. Otherwise, the whole thing becomes a waste of time.
Yes.
Parties have got to be prepared for it and know what's going to be advanced, and have the opportunity to put in evidence if they need to on whatever points that are.
All right. Well, we've heard that.
Very good. Thank you, Marlon.
I mean, the difficulty is that without knowing what sort of points are going to be raised, one can't make a blanket order that there be something 3 days in advance, 2 days in advance, or whatever. But you will know the sort of things that are capable of being resolved in short form, and what need evidence and what don't. And I just have to rely on your good sense to work that out.
Would it be worth your lordship just indicating that to the extent possible, the parties ought to try to agree an agenda 7 days before any of the case management hearings at the very least?
Yes.
Yeah.
There may be issues which arise which are not applications,
yes,
but they just need to be sorted out, and then everyone will know where we are.
Yeah. No, I think I'm grateful to my learned friend. That seems like a very sensible suggestion. I don't know if that needs to go into the order. I mean, his lordship, I think, has approved that. So
yeah, well, no, let's put it in. Let's put it in.
Fine. Okay.
Parties seek to agree an agenda 7 days in advance of any case management conference.
Very good. We'll put that in. I think the next item was the third party disclosure. Sorry, my lord, can I just check with my junior where we are on that? Is that contentious?
Oh,
If it's contentious, we're leaving it.
yeah.
Oh. Sorry, I think it might be contentious, my lord. In which case, I think that needs to be pushed off, and the parties can discuss that and see where they get to. So you can delete, I think, paragraph 10 from here, and that will have to be picked up in discussions. And then I think our paragraph 11 can actually be deleted, but it will be replaced with the process that your lordship has mentioned, where we examine your diary and see what you can offer us, and then the costs can be cost in the case.
Yeah.
So if we just have a little agenda as to what remains outstanding,
Yes.
We haven't dealt with quote sampling issues. We haven't dealt with foreign language stuff. We haven't dealt with the list of issues, all of which were raised at one time or another.
That's correct. I mean, I'm not holding my breath, but it seems to me that this might merit from a bit of further discussion and scrutiny by the parties, because we do have to keep these hearings to the big picture issues rather than the minutiae. And
my lord, I've got a slightly longer list of things left over.
Yes.
So foreign language search terms.
That's what I had meant by foreign language. Yeah.
Sampling you mentioned, and list of issues. There's also telephone recordings. I'm hopeful which loads. And then I've got third-party disclosure or request for documents by the liquidator, and then information from the liquidator were the other points. I'm hopeful that the large amount of that will be capable of agreement one way or another. I'm sorry, you're struggling to hear me, and I think it might be because I don't know where my microphone is. I apologise for that. But so that was it. I've got, in addition to yours, then telephone recordings, third-party disclosure, and information from the liquidator.
Yes, remind me what the information from the liquidator point is.
That is in relation to, good point, the gaps that the liquidator has said exist in the first defendant's documents, and I think they have said that some of them have been sorted out, some of that has been resolved, gaps have been filled, and we have a series of questions about that, really. Essentially, the disagreement between us is the claimants say very happy to provide the information, just not by way of witness statement. I'm not sure we much care as long as the liquidator puts her name to it, such that if needs be, so she can be questioned about it in due course. But we need a date for it, that's all.
Okay, yeah.
Well, I think that can be followed up in correspondence, but I'm grateful to my learned friend for clarifying his position. Thank you. So, my lord, I think that concludes the day's proceedings, but can I thank your lordship on behalf of both of us that you've taken a whole day when you only billed for 2 hours, and same for the court staff as well and the transcriber.
Very good. Are we talking costs in the case or costs reserved? Those are the only two options, so far as I'm concerned.
I think I think we'd see it as costs in the case.
Yeah, very good. Everybody seems happy with that. Very good, costs in the case. All right, thank you very much. And you'll produce a draft order for the registry, please, Mr. Shivji.
I will do. And I'll run it. Obviously, I'll run it past Mr. Montague Smith before it comes to.
Of course, naturally. Yeah. All right. Thank you all very much indeed. And thank you to the court staff too for being tolerant with over lunchtime and similar issues. Thank you very much. Unless the court staff want to have a word with me, I was planning to sign out myself, but if everybody else would sign out, then they can tell me whether they want to talk to me or not.
Very good. Thank you.